Ray. Hi,
Hi.
ready?
Sure.
We're still going, right?
That's what I'm, yeah.
Okay,
I
any,
thought raise, kind of like I said yesterday, we really got into the blue, so.
yeah, okay. Um, anything that you want to take up prior to any kind of motions and
We were
limine?
just discussing the complaint, not addressing the prior. It's not charged as a second, it's put on there as a enhancement paragraph.
It's not a jurisdictional.
So from what I can see, it doesn't look jurisdictional. Yeah.
Is it Martin?
Gomez.
Yeah.
Basically, that wouldn't be in our case in chief, it'd be on punishment.
There you go. That's pretty good.
Because they've also got the 0.15 alleged on there. That is in the case, that has to be in the case in chief.
Right. But the
So
second is
just,
not.
just the 0.15 itself makes it a class A in and of itself, right?
Right. And normally we wouldn't,
I mean, I see that there is the,
right, but it's not a jurisdictional enhancement, Gerard. It would just be a punishment. So it wouldn't be in our case in chief, it would just be in our punishment case.
sure,
Right,
of course.
but it's not, that's what we were just trying to figure out.
Right, because the 0.15
It mentioned
during case in chief, right,
Correct. Correct. The only time you do that is on DWI thirds, because that is jurisdictional.
right, because that's jurisdictional.
yeah,
You're
you're
right
right.
to make it a felony.
Cool.
Yeah, so I think that's really, and I'd
Also,
also like,
don't mention the 15, you know, right?
Well, I think that would.
And when you're arraigning,
No, oh yeah, when in arraignment, no, obviously, I was, during the case in chief, though, we would have evidence, obviously, but yes,
Sure.
during arraignment, no.
okay,
and then I would also like for the state not to mention anything to have to do with his immigration issues or ICE hold or anything to that
We are
effect.
completely in agreement on that.
done.
Thank you.
Just always remain over there.
Yes, sir.
So for purposes of voir dire, what I'm going to do is I will do voir dire as we always do, okay? If we have to bring people up to do more questioning, so to speak, I'm gonna kill them so that we don't get names, faces, because I don't want that.
So do you not want us using names and?
Yeah, please just use numbers, your numbers. And then when we come up to do the more personal questions, I'm gonna cut the live stream. So that it doesn't, and then when we start after that, then I'll. put it back.
Okay.
Okay.
I swear to God.
I don't care what, dude, ball's in your court. You do what you wanna do. I don't micromanage at all. Voir dire's in your court, and you ask what you wanna ask. Just don't ask improper commitment questions, right?
Yeah.
The only question I have is, say, like,
Last time I did this.
I don't know, no, I just go through a generalized, you know, hey, who can be here, who can't, and I'll leave it on you guys to do the rest, but.
I'll pull it up.
All right, ladies and gentlemen, we are about to bring in a panel. We're about to start voir dire. I need you no talking whatsoever. If you need to talk, go outside. If you want to use your cell phone, go outside. Hey, is he in shackles though? Are they keeping him in shackles? You know if they're keeping him in shackles? Because then, if so, then they need to bring him out first so they don't see him.
Yeah.
Hey, oh, it's going. Okay, they're gonna take it off, so it's good. That's fine.
Yeah, but they don't dismiss. Oh, yeah. Five, they're checking. Five, checking. So five plus, yeah, done out plus, and then I.
Well, it's a crime of moral turpitude.
yes,
Excuse or not? Not to excuse.
death by check, right? Death by check, class A, I believe. is a
Deferred.
very small turpitude. Deferred, but that's the only.
Successfully completed?
I think so, it looks like.
That's not a conviction.
It's not, right?
Okay. Guys, we are going on the record. Please do not talk. If you need to use your phone, go outside. We're going on the record. No talking. All right, bring the panel in, please.
How long do we have to?
20? 30 max?
30 max? Yeah,
30 max, no more.
All right, for the jury.
All accounted for? All right, everyone, please be seated. Good morning, everybody. Thank you so very much for coming. My name is David Fleischer. I am the judge here of Harris County Criminal Court at Law number 5. We are but one of 16 county criminal courts here in Houston. I'm going to go through the top because I don't know what you know. I don't know what you've heard. I don't know what anybody's been told to you. So I'm going to go as if you guys don't know anything. So what are we? We are a criminal court. There are 2 types of criminal courts, actually 3 types. There are district courts that handle felonies. There are county criminal courts that handle Class B and Class A misdemeanors. And then there are municipal/JP courts that handle Class C. If you ever get a speeding ticket, if you get, believe it or not, a Class C assault or something of this nature, you will go to municipal court. Now, Houston, Harris County is so big that we can't just have a municipal court. We have to have outliers all over the city because, I mean, really, from one part of Houston to the other, it takes you 2 to 2.5 hours. And that's probably without traffic. Because of that, we have justice of the peace that are scattered everywhere that handle Class C cases. Now, what are Class C? Those are the types of cases that are punishable by up to a $500 fine. We here in county criminal court handle Class B and Class A misdemeanors. So a Class B is something that's punishable by up to 180 days in jail and or a $2,000 fine. And a Class A, which is the worst of the misdemeanors, are punishable by up to a year in jail and or a $4,000 fine. We have 16 county courts, and then there are 22 district. Actually, there may be more now. Did they add more district courts?
They did.
I think
Yeah.
4.
Business is so good down here that they have to add more, which is not a good thing, right? I mean, we try to stop as much as we can, but you know, it just happens sometimes, right? So they've had to add more district courts just because of the number of cases that are they're just popping up. I know that you don't want to be here. I know it's a burden to you. I would rather be playing Fortnite at home too. So I'm sorry to drag you down here. Really, I am. But I need you. You know, statistically speaking, we live in what, 3 million people? 5% of those upon call, 7% of people who are called upon jury duty actually show up. Do you realize that? It's just abysmal. So I'm so proud of you for coming and doing your civic duty. I really, really thank you. And really, if we didn't have you, it would be complete chaos because how would anything function? So really pat yourselves on the back, you know, and for those who are selected, you're going to get a whopping $40 a day and lunch. So thank you so very much for coming. We are here for a trial today, as you very well may figure out. It's a DWI. And I anticipate this case to last for 2 days, today and tomorrow. Is there anyone that cannot be here tomorrow for any reason whatsoever? They've got plane tickets, a doctor's appointment that they've made for months. It's okay. We bring a lot of you guys because I anticipate there are going to be issues. What I really, really don't want is to impanel a juror and then, oh, I can't make it tomorrow. It's okay. Anyone that can be here tomorrow? And please, when you answer up, please do so by your juror number. Juror number 15. No, just no can do tomorrow. Not just because I've got I just don't want to come or I've got.
Cancel the appointment. I've got a back issue and the doctor has me scheduled for.
Oh, I'm okay with
That's
it.
it. I can
Okay.
cancel it.
Not a problem, really. I'm happy that you're here. We try to accommodate as many people as we can. Is there anyone here that doesn't speak English or doesn't understand English very well? It's okay. Anyone. I'll tell you that no matter how many times we do this, I still get jitters in my tummy because I'm not a very good, orator or speaker. So if I fumble my words, I'm sorry. It's a serious case. DWI is something we take here very, very seriously. I don't think that any of the people here disagree about the law. Well, they disagree about whether the law was broken. And that's why we have trials, so that people can listen and make a judgment call. We're not asking any of you to split the atom, do Pythagoras' theorem. All we want you to do is listen and make a judgment call. Really, you in your gut will know if you hear someone testifying, whether they're in left field or outer space, or they're just completely wacko, or whether they know what they're talking about. It's just common sense. Is there anyone here that has some kind of experience that they don't think that they'd be able to sit for a DWI trial? You know what? Let's do this. I'm going to let the lawyers get into it because I don't want to start questioning you here. They're each going to get about 20 to 30 minutes to ask you questions. Please let them know, because what we don't want is someone who already has a preconceived notion how things should go. All we want you to do is keep an open mind, leave everything at the door in the past, just come in, listen, and make a judgment call. I'm going to first, before I let the lawyers talk, I'd like to introduce them to see if anyone knows anyone in any of the players here. Will you please stand up and announce yourselves, introduce yourselves?
Good morning, everyone. My name is John Denver. I represent the state. Fleischer, I represent the state of Texas.
Anyone recognize them? Okay, you may be seated. Defense.
Good morning, everybody. My name is Ray Vasquez. I'm representing Mr. Gomez. And assisting me today is Abel Izagiri.
Anybody recognize them? Okay, please be seated. Now, without further ado, I'm going to let you have the floor.
All right, good morning, everybody.
Morning.
So like I said, my name is John Denport. I represent the state in this case. And like Judge said, it is a driving while intoxicated case. Let's get into it. All right, in this country, the defendant is innocent until proven what? Anybody can say it, shut it out. Correct. I'm the only person that can do that. Nobody else has to do that. Defense doesn't have to do anything. It is completely our burden, the state's burden, to prove that to you. So to do that, we have to do a couple things. We have to show, beyond a reasonable doubt, that the defendant, on or about October 6, 2024, in Harris County, Texas, and like I said, the defendant, operated a motor vehicle in a public place while intoxicated. Right? Simple enough, pretty straightforward. We have to prove each and every one of those beyond a reasonable doubt. We'll talk about that in a little bit. But first, I want to talk about intoxicated. What does intoxicated mean? Anybody have any ideas? You can just shut it up.
Very good.
Under the influence.
Under the influence. All right. Anybody else? Drunk. Yeah. Pretty straightforward there. But let's talk about the legal definition. So there's the legal definition is that intoxicated means the loss of the normal use of your mental faculties due to the introduction of alcohol or drugs, or that you've lost the normal use of your physical faculties due to the introduction of alcohol or drugs, or that you have a blood alcohol concentration of 0.08 or higher at the time of driving. Now, has anybody ever seen a drunk person?
Yes.
How did you know they were drunk?
Staggering.
Staggering. Okay, what else?
Slurred. Slurred.
Slurs. All right.
Slurred speech.
Slurred speech. Anything else?
Talk a lot, smack.
Talk about smack.
Irritable.
Heard that one before. Irritable. That's another good one. All right. Did you know? Anybody who did you know what their blood alcohol concentration was?
No.
But you still knew they were drunk, right? So, and what's important to note here, I don't have to prove two of these. I only have to prove one of these, right? So if I show you one of them and I prove it beyond a reasonable doubt in your mind, right? That means I proved that element there was oxygen. Okay. But you don't always have necessarily 0.08, right? But like you just said, there's a whole lot of ways to be able to tell if somebody's drunk. So if I show you one of the other two, and I don't give you a blood alcohol concentration, then, but I do prove beyond a reasonable doubt, you still have to find the defendant guilty, or to show, or at least find that I proved that element was me. If I prove all my elements, right? Let's say for this hypothetical, I prove every single one of my elements beyond a reasonable doubt, including this one. But let's say I don't show you that they were above 0.08 at the time. Is there anybody here that would be incapable of finding the defendant guilty, even though I proved all my elements to you? Anybody? It's okay. I just need. No? All right. All right. So, got a little story for you. So these are my two granddads, right? Over here on the right, this is Mike. And on the left is Don, right? So Mike is a wine drinker, right? And as soon as he opens that bottle of wine, as soon as he smells it, he already starts getting giggly. You can look at him and he looks like he's drunk, right? Automatically. As soon as he sniffs that wine, as soon as he smells it. And then you have Don. Don is a whiskey drinker. And Don can drink all night long. And he never changes, right? He's the exact same, he's telling the exact same joke, acting the exact same way, and you never know he's drunk. So let's say that one night you're hanging out with Don, and you watched Don, and you watched him drink whiskey all night. And Don turns to you and he says, I'm a little hungry. Let's hop in the truck, run a Whataburger. I'll drive. Is there anybody here that's going to get in the truck with Don?
No.
Why not, though? He looks fine, doesn't he? You can't tell.
Yeah, but if you saw how much he was drinking, that's just a telltale sign that it wouldn't be in your best interest to
So-
ride with him.
Even though he might not look drunk, but you knew that he drank a lot.
Is he capable of driving?
So, well, for the purpose of this hypothetical, he's drank a lot. We're just gonna say
My
that.
question is he capable of driving?
Well, for the purposes of this hypothetical, let's just stick with the fact that he's drank a lot of alcohol. But you don't know exactly how much.
The
So,
reason why I asked that question, I got one who can drink all day and still drive it smooth.
okay,
So that's why I asked the question.
so if, let's say that uncle, would you get in the car with that uncle?
Maybe, maybe not.
Depends on the day.
Yeah, depends on how I'm feeling that day.
Okay. All right. So let's say that I was able to show you that, a certain. Let's say that I proved beyond a reasonable doubt that the defendant was above the point, right? But you thought from whatever you saw that the defendant was still capable of driving. Like that uncle was driving.
Yeah.
Would you still be able to find the defendant guilty and follow the law that says that if I show you he's above the .08, you've got to find the defendant guilty? If I prove to you beyond a reasonable doubt, you still be able to find him guilty.
I'm gonna object, Your Honor, that's my question.
Restate the question, please.
If I prove to you beyond a reasonable doubt that the defendant was above a .08
Mhm.
and was intoxicated by the level of law, and I prove to you all my other elements beyond a reasonable doubt, would you still require me to prove that he was incapable of driving, like you were talking about? Even though I put all my elements beyond reasonable doubt.
First of all, I recommend you stop driving.
But just yes or no,
Yeah,
you'd be able to find him guilty,
yeah.
or you need me to prove more?
Well, I mean, his flood that was, what, 20? Yeah,
You'd be able to find him guilty?
yeah.
Still a commitment issue, Judge.
Please don't ask just these commitment issues. Ladies and gentlemen of the jury, remember, back in the old days, we didn't have all these things. There were no blood tests. There were no breath tests. There was no videos. With the advent of science, with new technology comes better aids, right? But at the end of the day, common sense dictates. You know what you see. You know what someone looks like when they're a particular way. Just use common sense, right? Everything else is just.
All right, let's move on with it. All right, so I talked a little bit about beyond reasonable doubt, but what does that mean, right? Surely there's a definition. Not so much. But what it is, I can tell you essentially what it doesn't, right? It does not mean beyond all doubt. It doesn't mean beyond a shadow of doubt. And it doesn't mean beyond a certain number of percent, right? 95% sure, we don't use that, right? You just have to base it on your common sense and your life experiences. Okay? So, for this next exercise, I'm going to show you a picture. And it's going to be blocked out. And then I'm going to go through each slide, and each slide is going to reveal a little bit more of the picture. Okay? So, once I get to a point where you see enough of the picture, where you think you know what it is, beyond reasonable doubt, I'm going to ask that you raise your jury card. All right, has everybody got that? Anybody have any questions about that? Everybody good? All right. All right. Anybody know what this is? The whole picture, sorry. No? Anybody have any guesses? It's a place. All right, I can tell you that much. It's a place. Anybody know what place we're at? Just based off that little sliver? All right. Good. Anybody know? It's got a specific name. It's got a proper name. All right. Anybody now? Okay, but are you beyond reasonable doubt? Are you sure beyond reasonable doubt that is what you're saying?
Beyond reasonable doubt, not yet.
Okay, all right. Just when we're beyond reasonable doubt, all right, everybody? All right. All right, anybody now?
Yes.
All right, go ahead and raise your jury card if you are good beyond a reasonable doubt. Raise them high, please. All right. Don't put your cards down now. All right, who's left? If there's anybody left. All right, now, anybody? Those still left? Okay. All right. So yes, it was Stonehenge, all right. It was a good guess. But you see, that's kind of how beyond reasonable doubt works, right? So when we look back here, here, you said you thought it was Stonehenge, but you weren't sure, right? Why weren't you sure? What was the feeling that you had?
Well, I've seen, a lot of pictures of Stonehenge. It look like that there are some copies elsewhere
Okay.
that are smaller scale.
So, but when we got to here, you saw that, and that's when you decided. You thought, okay. So everybody can kind of see, right? I still don't have the full picture, right? There's a lot missing. Like you said, there's copies, there's other things elsewhere, right? But if I have enough of that picture, then I can still say that it's beyond reasonable doubt, even though I don't have everything that's there, right? And that's kind of how trials work. That's kind of how evidence works, right? There's might be some things that we're just not going to know. But it can still be beyond a reasonable doubt if I show you enough of that picture. Does that make sense, everybody? All right, so let's talk about evidence, right? You've already said it's a DWI case. So what kind of evidence do I expect to see in this case? Anybody, you can start anywhere. Crash, we said crash car, maybe.
Maybe a video of catching speeding,
Okay, what else?
maybe an offense report.
Okay,
Like, sobriety test results.
okay,
Witnesses?
Eyewitnesses.
eyewitnesses, okay, anything else?
Blood alcohol test.
Okay, anything else?
Medical history.
Those are all good answers. Now, like we said, and we talked a lot about beyond reasonable doubt. And we talked a lot about the elements. But is there anybody that would need a specific type of evidence in a DWI case, right? You said blood evidence. Is there anybody that would need a specific type of evidence before you could find the defendant guilty? Even if I proved all my elements beyond reasonable doubt,
Did he hit someone?
you would need to know that evidence? Or
Yes, did he hit someone?
did he hit someone? If he didn't hit someone, would you be able to find him guilty? Even if I proved all my elements beyond reasonable doubt? Possibly.
Yeah.
Okay. Anybody else need a specific type of evidence? You said you need to know the speed.
Right,
So,
could have been keeping up with the speed of traffic, causing an ailment to drivers behind it.
okay, so if I didn't have what speed you just going, but I proved all of my elements beyond reasonable doubt, would you still be able to find him guilty?
Maybe.
Maybe, and I just said yes or no, and I'll
No.
repeat that for the record. No, you would not be able to find him guilty, even if I proved all of my elements beyond reasonable doubt, because you didn't know what speed. Thank you. Anybody else? Juror number 2.
I think I need a report for breathalyzer, blood alcohol content.
Okay, so even if I prove to you, because we already talked about, remember back there, we talked about the definition of intoxication, those are all ors. I only have to prove one of those two to meet that element, right? So you're saying that even though I prove my case beyond a reasonable doubt, if you don't see a blood alcohol test, you're not going to be able to find it.
Maybe a push, Judge.
The alcohol.
Sure. Repeatedly trying to get them to commit to something, you know? Either rephrase it or. You know,
I can rephrase that question. I was just trying to clarify exactly what you're saying.
Well, in fact, I understand what he's trying to do, which is that he's trying to get, angry. So I think it needs to be rephrased to where it's not. Those seem like my questions to me, that would be my opinion.
Yeah, great. It is, if you're trying to commit them to something, like you should. All right.
She can hear, Judge. She can hear.
Oh. Okay, just. Mike, with this commitment, watch this shit. You can't. For some reason, I don't see a number. I can't find something guilty. Just you go look. I've given all the elements. Can you find them?
Okay, I just want to make sure.
Are you okay with that?
The can, I think is. I think
What would you suggest?
they could, would be probably better than they can.
Okay, so clears you find you guilty if all my elements met. Just don't keep harping on it. Start getting into the blood, stay on the breath test, right? Then it gets into commitments. You have nothing elements. Would you? All right.
All right, let's get back into this. So come back to you. So even if I prove to you beyond a reasonable doubt. Defendant was intoxicated. Don't see a specific type of evidence. Could you still find the defendant guilty?
Jurors, all you need is common sense. If you see someone, they're falling down, urinating all over themselves, just use common sense. You know what someone is when they're not. Like I said, remember, in the old days, how did they ever find someone guilty of a DWI? We didn't have these kind of stuff. They just used common sense, whether there was video, whether there was not, whether there were people testifying. When you hear someone, whether they're in outer space or not. Just use common sense. Please.
Thank you, Judge. All right, let's move on. Okay, let's talk about witness credibility. So, in the state of Texas, right, no matter what someone looks like when they walk through that door back there and get up on the stand, they all start at the same line, right? Doesn't matter if it's the Joker, Bruce Wayne, Nun, Snow White, or law enforcement, right? They start at the exact same line, regardless of what they look like, how they're dressed. It doesn't matter until they open their mouths on that stand and start talking. Then you can make judgments about credibility. Okay. So, is there anybody here that would give more credence to someone's testimony just because they come in dressed in a uniform with a police officer? Is there anybody here that would give them more credence? Give them more credibility? No? Okay. What about less? No? All right. Okay. Almost finished up here, y'all. So we have in Texas a two-part trial system, right? The first part is guilt innocence, right? That's what you're here to do. You are only here to decide if they are guilty or innocent. There are only two options. For punishment, you won't be concerned with that. All right? So you'll have no voice in the punishment. Is there anybody here that would be incapable of finding the defendant guilty if you have no say whatsoever in the punishment that he receives? Nobody? Everybody's good? Okay. Anybody else? No? Just making sure. All right. Okay, so for this next question, it's going to be a little different. All right, so here's what we're going to do. It's what we call a scaled question. So what we'll do is I'm going to go down the line. I'm going to say juror number 1, and then you're going to say your answer, say it loudly and clearly so the court reporter can hear. All right, so I'm going to ask, and not yet, but I'm going to ask, how important is it to you that we prosecute DWI cases? All right, here's one. How important is it to you that we, the state, prosecute these types of cases? Right? If it's not important to you, juror 1, you'd say 1. If it's somewhat important to you, then you'd say 2. Again, you see how that goes. It's important 3, very important 4. All right. So I'm going to go down the line and just say juror number 1, and then juror number 1, you'll answer with whatever number corresponds to your answer. Does that make sense? Everybody got that? Anybody have any questions about that? Okay, great. Let's start. Juror number 1. Juror number 2. 1. Juror number 3.
4.
Juror number 4.
3.
Juror number 5.
3.
Juror number 6. 4. Juror number 7.
4.
Juror number 8.
4.
Juror number 9.
3.
Juror number 10. 4. Juror number 11.
4.
Juror number 12.
4.
Juror number 13.
3.
Juror number 14.
4.
Juror number 15.
4.
Juror number 16. 4. Juror number 17.
3.
Juror number 18. 2. Juror number 19.
4.
Juror number 20.
3.
Juror number 21.
4.
Juror number 22. 3. Juror number 23.
3.
Juror number 24. 3. Juror number 25.
3.
Juror number 26.
3.
Juror 27.
4.
Juror 28. 3. Juror 29.
4.
Juror 30.
3.
Juror 31.
2.
Juror 32.
Definitely 4.
Juror 33.
4.
Juror 34,
4.
juror 35.
4.
Thank you. All right, and then we have one more, and we all kind of got out of that work last time, so that was great, y'all. So we're gonna do that one more time. And this time, it's a statement, and if you agree, you're 4, if you somewhat agree, you're 3, somewhat disagree, 2, strongly disagree, 1. All right, the statement is law enforcement is doing a good job in my community. All right, so everybody good on that? Everybody knows how we're doing that this time? Okay, great, all right. Juror number 1.
3.
Juror 2.
2.
Juror 3.
3.
Juror 4.
3.
Juror 5.
3.
Sorry,
3.
juror 5. Juror 5 indicated. Juror 6.
3.
Juror 7.
2.
Juror 8.
4.
Juror 9.
3.
Juror 10.
3.
Juror 11.
4.
Juror 12.
3.
Juror 13.
3.
Juror 14.
3.
Juror 14. Sorry, excuse me. Juror 15. Juror 16.
3.
Juror 17.
2.
Juror 18.
1.
Juror 19.
2.
Juror 20.
3.
Juror 21.
4.
Juror 22. 4. Juror 23.
2.
Juror 24. Juror 25.
1.
Juror 26.
3.
Juror 27.
3.
Juror 28.
3.
Juror 29.
3.
Juror 30.
3.
Juror 31. Juror 32.
3.
Juror 33.
3.
Juror 34.
3.
Juror 35.
3.
Thank you, everybody. All right, so,
2 minutes.
you're gonna state judge. Just one last question. Does anybody have any moral or religious reason why they can't sit in judgment of others? Anybody? No? Anything? All right, well, thank you so much, y'all. I look forward to talking to a few of y'all here in a little bit.
All right, thank you.
We have a moment to set up, Judge.
Sure.
We having fun yet? Of course we are. The answer is yes. It's always fun, right? All right, my name is Ray Vasquez, like I told you. I represent Mr. Gomez. Going to kind of go through some of the similar stuff the state went through, just probably expand on some stuff some more. Except now it's not working. Okay. All right, so a couple things Tom told you, it's the state's burden, right? Does anybody disagree that the state has the burden to prove the case beyond a reasonable doubt? They're gonna say, you know what, Ray, I want you to get up and I want you to tell me why your client's not guilty. Right, is anybody gonna say, Ray, I need you to tell me why your client's not guilty? Raise your hands, go ahead and raise your black card real high, I know somebody's gonna say that. All right, jury number 3, you would want to hear what our defense is, right? Even though it's the state's burden and the state's only burden, I could sit here and do nothing, right? Okay, everybody's heard of the Fifth Amendment, right? What is the main crux of the Fifth Amendment? Right to remain silent, right? Anybody watch cop shows? When you see those cop shows, what's the first thing they do when they arrest somebody? Read you your Miranda rights. What's the first word of the Miranda rights? You have the right to remain silent, right? Which means I can sit here and do absolutely nothing, right? Does anybody disagree with me? Juror number 3, you disagree with that?
I feel like, being with personal experience, I need to know why the defendant is here in the first place, because there are plenty of people that drunk while under the influence, but what was he doing specifically that got him in this situation?
Okay, well, you understand though that as he sits here today, he is presumed innocent, correct? Okay, everybody, does anybody disagree with that? Presumption of innocence, right? Okay, so what you're saying is you would have to hear from him in order to make a decision on this case, is that correct? Yes, I need you to say it loud, please, I'm sorry. Okay, juror number, I'm sorry, I think you're 14. You said the same thing, I saw your card go up.
I would just like to hear the defense, and you, basically trying to
debunk basically what the prosecution is saying.
Okay, but you understand it's not my burden to do that, correct?
Mhm.
So if we don't put on a defense, if we just sit there and remain silent and say absolutely nothing, you would still not be able to enter a judgment in this
So
case?
I would be able to.
Okay. Anybody else feel that way? Juror number 32. You feel that way?
Yes,
So you would have to hear from the defendant before making a decision?
yes.
Okay, and if he doesn't testify, you won't be able to make a decision one way or the other?
I think I'll be able to, but I still want to hear the other side.
Okay, I'm sorry to do this to you. Anybody ever, who's married? Where are my married people at? All right, so juror number 32 just gave us a perfect example of what I think, or maybe, or something like that. I think somebody earlier had said maybe, right? All right, all you married folks, and even if you're not married, you have a partner or whatever the case may be. Your partner says, I want to go to Vegas this weekend. I want to hang out with the boys, right? And you say, were you going to be faithful? I think I can. Or I think I will. Or maybe, right? Are you going to be satisfied with that answer?
No.
Right? Nobody's going to be satisfied with that, right? You want to know, right? I'm sorry to do this to you, but we need to know. Okay, so I need either a yes or a no from you. So if the defendant doesn't testify, would you be able to complete a finding in this case? Or would you require the defendant to testify, I guess is what I'm saying?
Yeah.
You wouldn't require him to testify? Okay, is there anybody that would require him to testify? Raise your flag real high. Alright. So it's the state's burden, right? Which means they have to prove everything to you. Everybody understands that, correct?
Right.
Alright. Unless proven what? So he's presumed innocent unless proven guilty, right? That word is important to me, unless, right? It's not until, everybody thinks it's until, right? Until means he has to be guilty, right? It's unless proven guilty, which means the state has to prove it to you beyond a reasonable doubt, right? Everybody's good with that?
Yes.
And they have to prove what part of their complaint do they need to prove? Just a little bit of it, portion of it, or all of it? Anybody? All of it, right? Not just each one, and you can't just say, yeah, I think that's true. It has to be, each element has to be proved beyond a reasonable doubt, right? Juror number 10, I see you shaking your head.
Yes.
Am I correct in that?
Yes.
Thank you. Okay. So, y'all seen these signs on the road, right? Everybody's seen the signs there everywhere, especially come 4th of July weekend, Memorial Day weekend. We just see those things, the text stop signs come up and they're just automatically saying, drink, drive, and go to jail, right? In fact, the prosecutor even told you, kept saying drunk, 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 right? Drunk is not the law, ladies and gentlemen, right? Drunk is not the law. The law is driving while intoxicated, right? So drink, drive, go to jail, that's incorrect, right? Is it still legal for you to go out, have 2 glasses of wine or 2 beers at dinner and still get behind the wheel of a car? More likely than not, right? Unless you're 5 foot nothing, 100 and nothing, then 2 beers might get you beyond the limit,
Right.
right? But 2 beers, alcohol has raises your blood. 1 beer or 1 glass of wine or 1 shot raises your alcohol level 0.02, right?
Objection, Your Honor. You're sitting the jury. Can we approach?
Hold on, what was your question? What was your question?
I was explaining how alcohol affects the body. Raises the blood alcohol 0.02 per gram.
What's your objection? I mean, probably better not to get in statistics now, you know? Okay. Fine.
All right, so based on your weight, size, all that good stuff, you could potentially be okay with 1 to 2 beers or 1 to 2 glasses of wine. Does anybody disagree with that?
It goes by your weight.
Goes by your weight
time.
and the amount of time. Okay. Does anybody disagree with that? Yes, sir. Jury number 22.
Yeah, unless you're disagreeing with what the state said earlier, there were 3 elements, only one of which needed to be proven. And the other 2 have nothing to do with measured alcohol content.
Correct. Right?
So
But
oh,
yeah, I'm sorry. And I'll clarify for you.
Yeah.
Okay, so the prosecutor kept saying drunk, 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 right? Do most people, on average, with 1 to 2 drinks, are they just completely drunk, falling over, staggering, can't speak, anything like that? Right? No?
I don't drink alcohol.
Or you don't drink at all?
I cannot.
So if you have a whiff of alcohol, you might feel that way, right?
If I have a couple of sips of my bread, I'm out.
Okay.
That's it.
All right, so it depends, right? But on average, 1 to 2, you're not gonna be stabbing all over your plate, so you're not gonna be urinating yourself, anything like that, right? So there are exceptions, of course, but for the most part, most everybody's not gonna do that way. Does anybody disagree with that? All right, so again, drive sober or get pulled over, drink, drive, go to jail, drink, and go to jail, right? That's what we've all been taught, and we know that's not the law. It is not illegal to drink and then drive, as long as you're not intoxicated. And as Juror 22 pointed out, there are 3 ways to prove intoxication. Right? The state told you what those 3 ways were. They don't have to prove all 3 of them, they just have to prove one of those 3, right? But like what was your number again? 27. She has 2 sips, she might lose her mental faculties, right? She might lose her physical faculties, right? So that would be enough for her to technically be intoxicated under the law, even though she may not be drunk, as the prosecutor kept saying. Does everybody see the big difference? Right? Does anybody disagree that there's a difference between intoxicated and drunk? All right. All right, so going to my drinking patterns, going to juror number 27 again. Juror number 27 said she doesn't drink at all, right? So she would be a D or an E. Okay. Now, sometimes we have to cover your alcoholics. It would be E's, right? Okay. So I'm going to go down each line, all right, and you're going to tell me what your drinking patterns are. And just go from there. So A, you drink regularly. That doesn't mean you drink every day or anything like that. But like me, Easter weekend, I had a few beers over the weekend. Everybody was over at the house. We were by the pool. I had a couple beers. Right? I would consider that regular. Right? Occasionally, only on social events, things like that. Rarely, you know what? If I feel like it, maybe I'll have a sip or 2. Never, like juror number 27, or not anymore. Okay? Everybody good with that? Juror number 1. C. Juror number 2.
B.
Juror number 3.
B.
Juror number 4.
E.
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 Juror number 5.
C.
Juror number 6.
B.
Juror number 7.
C.
Juror number 8.
C.
Juror number 9.
See,
Juror number 10.
B.
Juror number 11.
B.
Juror number 12.
E,
Juror number 13.
A.
Juror number 14.
B.
Juror number 15.
C.
Juror number 16.
C.
17.
C.
18.
A.
19.
C.
20.
E.
I'm sorry?
E.
E. E. E. Yes, E. Juror number 21.
C.
C. Juror number 22.
C.
Juror number 23.
E.
Juror number 24.
C.
25.
B.
26.
C.
27.
B.
28.
I'm sorry, what was you saying?
D. She's my 2 sips and she's out. I'm sorry.
that's all.
You were self-admitted to it, so, I mean. 28, I'm sorry, what was your answer?
B.
B. 29. 29 was A. 30,
B.
31,
C.
C. 32,
A.
A. 33,
A.
34,
A.
35.
B.
Oh, my partner's in the back. We gotta hang out after this. All right. I don't want to get too specific on any of this. But has anybody ever had any issues with an accident while they've had alcohol in their system or an arrest? Or has anybody dealt with alcoholism? If you don't feel comfortable talking about it up here, if you want to approach afterwards, just raise your placard card and we can talk about it at the bench afterward. If not, if nobody's had any issues, then I'll just move past this. Anybody? Personal issues, direct issues. Okay, turn number 2. Which one? If you mind, or do you want to approach afterward?
Approach after.
Okay, turn number 13? After. Okay, anybody else? 20 and 32? So I got 2, 13, 20, and 32. Approach afterward? Is that what y'all want to do?
I know.
Okay.
Alcoholism.
Alcoholism? Okay. And 20, did you want to approach afterward? Alcoholism? All right. Who's heard of MAD? Mothers Against Drunk Driving. Raise your hands if you heard of the class. All right. Anybody donate to them or anybody participate in them, anybody give money to them or anything to that effect? Just raise your placard card for them. 15. Donate?
Family, yeah,
Family?
my wife did,
Okay.
but we did.
Gotcha. Anybody else? All right. All right. Now comes the fun part. I'm gonna knock you out. Who's a cop? I know somebody in here is a cop probably. Anybody? Police officer, nobody's a police officer, former police officer? All right, anybody have family that's a police officer or a district attorney? Turn number 2. You have family? Brother? Okay. Anybody else? Turn number 7.
Uncle.
Uncle. Juror number, anybody else on the first row? Juror number 9.
Yeah, cousin.
Cousin. Juror 21.
Cousin.
Cousin. I saw another placard on the second row. Anybody else? Juror number 29.
Uncle.
Uncle?
Yeah.
Okay. So, going down the line, juror number 2, with your brother being a police officer, would you automatically feel like a police officer is automatically credible? And would you give more weight to the testimony of a police officer in a situation like this?
I feel like I would, because they've had training.
Okay, and do you feel that that would not make you a fair and impartial juror in this case? And again, I gotta ask the question of yes or no?
Yes.
Yes, okay, so you cannot be fair and impartial, correct? Okay. Juror number 7, same questions to you. Anything about your uncle being a police officer would automatically give you rise that a police officer is automatically credible?
I would say yes.
Okay, and do you think,
Well, you'd ask to be more credible.
okay, and do you think that you would not be able to be a fair and impartial juror just because of your,
Then I think I could still.
again, I can't accept, I think, it's yes or no.
Repeat your question.
Do you feel you would still be able to be fair and impartial even with the relationship you have with your uncle?
Yes.
So you can be fair. Number 9,
Yes.
yes, you can be fair and impartial. 21,
We'll be fair.
okay,
Yes.
and 29, yes? You said it was your uncle, right? All right, anybody related to or ever been a prosecutor in this county or any county? I know I've got Harris County up there, but any county, anybody related to or been a prosecutor themselves? Raise your hands. No? All right, big deal. Anybody been a defense attorney? Who's my lawyer? Where's my lawyer? There he is. kind of law you practice, Jared, number one? Corporate law?
Yeah.
Okay. All right. Wow. I gotta make the font a little bigger on that. Presumption of innocence. I know I harped on this early on. I'm gonna harp on it again. Why? Because it's extremely important, right? 0 being completely innocent, 10 being guilty, and he's here for a reason, so he's got to be somewhere in the middle. Maybe he's guilty, maybe he's not. I'm going to ask you to give me an answer based on 0 to 10. Just that answer, okay? Everybody understand that? So 0 being completely innocent, you're going to automatically assume he's innocent. 10, you're going to think he's guilty already without ever hearing any evidence, or you can fall somewhere in the middle. All right? Any questions on that?
I don't either. I don't know.
Okay. So I'm going to ask you.
How do I know? I mean, just because you're saying it because he's here?
That's what I'm asking you. So
Just.
I'm going to ask you.
I don't think that's a fair question.
No, it's not.
No, not gonna work.
Okay. So they're automatically assumed innocent, correct? Right? Did everybody understand that? There's a presumption of innocence, right?
Under the
I'm
law.
asking, under the law, there's a presumption of innocence. I'm asking you your personal feelings, whether or not you can go a 0, or you're gonna be
I
at a
have
10,
no evidence.
or somewhere in the middle.
I have no evidence.
As it stands right now, sir.
I have no feelings about it because I.
Okay, so you would be a 0 then, right?
No, I don't think he's presumed innocent. I don't think he's presumed guilty.
Okay, you understand that the law requires that there's automatically a presumption of innocence, correct? Even as we sit here right now, he's presumed innocent, right? That's the law. Do you understand that?
But you're asking me to say what I think about this case when I hear.
I'm asking about the presumption of innocence. Right? So,
We're here because of this case.
correct. So I'm asking,
And you're asking me how I feel about his guilt or innocence.
Correct.
About what the law says.
no, I'm asking how you feel about the law and whether or not you can give him the presumption of innocence
It's
as
how
we
you
sit
feel
right now.
about his guilt or innocence.
Right, as we sit right now.
Answer that question.
Okay, as we sit right now, I'm asking for either a 0, a 10, or somewhere in the middle. Okay, does everybody understand that?
Yeah.
Okay. And what's your number, sir?
23.
23. Thank you, sir. All right, turn number 1.
You're up.
Turn number 2.
Aye.
Turn number 3.
5.
Turn number 4.
0.
Turn number 5.
2.
And I'm sorry, that was a 2? Turn number 6.
0. I'm sorry, Ray, can you do number 4 again?
1 was 0, 2 was 5. 3 was 5, 4 was 0.
Okay.
Okay, I was on 6, 7. Turn number 7.
0.
Turn number 8.
5.
Turn number 9.
5.
Turn number 10.
5.
Turn number 11.
8.
Turn number 12. Turn number 13.
5.
Turn number 14.
0.
Turn number 15.
5.
Turn number 16.
5.
Turn number 17.
5.
Turn number 18.
0.
Turn number 19.
0.
20.
0.
21.
5.
22.
0.
23.
5.
May we approach, Judge?
We got a couple minutes left, so. I think that's a mistaken question. You know, it's a misleading question because people would like to be fair. They don't understand the question. They're gonna say 5 because I want to be fair and like right in the middle. You know, a lot of people didn't understand the question was five. So they're arguing with you, they just don't understand it. You know? I don't know if you busted anyone yet, and so we can look at people don't understand it, and they clearly had like 4 to 5 people that didn't understand it even after you tried to go over it 3 times. So I mean, continue with it. Let's just continue with it and go. Okay. We'll bring him up. I don't think it was.
All right, where was I? 24. 25. 0. 26. 27. 28.
0.
29. 30. 31. 32. 33. 34. 35.
2.
Okay. What's that say? Jumping to conclusions, right? Kind of like with our Stonehenge picture, we haven't seen the whole thing, right? We just assume that says jumping to conclusions, right? That's not what it says at all. Okay. So, yeah, how do you pronounce it? I have no idea, right? But everybody just assumed you saw a little bit and you knew, hey, I know exactly what that says, right? This is reasonable doubt, ladies and gentlemen, right? Just like the Stonehenge picture, you gotta see the entire picture before we get there, right? Reasonable doubt. Now, prosecution showing you that Stonehenge picture, that's pretty good, right? But it got about halfway, and then right about halfway, everybody can see exactly what it was, right? Well, halfway gets us, oh, that's not gonna show up. That gets us to about reasonable suspicion or maybe probable cause. Everybody sees the steps, right? My corporate lawyer, what's the standard in a civil case? Preponderance of the evidence, right? Just a little bit over halfway, right? Anybody know who CPS is? What CPS does? Right? They take away your kids.
Objection, Your Honor, receiving proof.
Overruled. Continue.
CPS takes away your kids, right? What's the standard for CPS to take away your kids? Anybody know? What's the standard as far as proof is concerned? Clear and convincing evidence, right? So right between preponderance of the evidence, my civil lawyer over here, which is when you're arguing about money, you just gotta be like a little bit above what you know, the evidence is a little bit there, right? Take away your kids, it's a little bit further. But to find somebody guilty, you have to get 2 more steps, right? Everybody see that? So you gotta get beyond clear and convincing, which is take away your kids. To the next step, reasonable doubt, even if they get to that step, they still have to make it to the next step, which is reasonable doubt, right? You have to get all the way up that staircase. Does anybody have a problem with that? Does everybody understand that? All right, so I think I'm about out of time. Thank you all very much for being here. Jury service is a very important aspect of our criminal justice system, our judicial system altogether, but especially in our criminal justice system. So I do thank you all for being here. And with that, I'll stand down. Does anybody have any questions for me?
Did you drive after drinking your beers?
Sorry?
I said, did you drive after?
I was at home. I stayed home. Yeah, I was at home. Took a shower and went to bed. All right, thank you all very much for your time.
Ladies and gentlemen of the jury, DWI is extremely serious and we take it seriously. Both the sets of the lawyers got up to ask you questions to see, would you be the proper juror in this type of case? Because not everybody is, and it's okay. We get it. You have things that happen in your life that may really have a profound impact on you where you may not be a good juror for a certain type of case. We get that and we understand it. And that's why they're up there asking you questions. It's not to trick you, this, to see. Have you already found this defendant guilty by virtue of just walking in here? That's what we want to know. Will you keep an open mind and listen to everything? Don't make a judgment call. Don't listen to all this jibber jabber about it. No. All you do is you listen to testimony, you look at evidence and make a decision. I told you at the beginning, it's not rocket science. We're not asking you to do Pythagoras theorem. No. Listen, in your gut, you will know when someone really knows what they're talking about, and just make a judgment call. That's all there is to it, right? If you have things that have so impacted you, okay, let us know. We'll bring you up individually. We'll talk to you. And if you're not the best juror, that's okay. Perhaps you are for the next case. With that, lawyers coming up, let's do it. Here's the mic, guys. So we're gonna ask you to speak into here so that she can hear everything. Okay, so. Well, say. Ready? Okay. Do you guys have any challenges for cause? Oh, okay, so let me start out in the outset. Juror 15 can't be here tomorrow because he's got doctor's appointments. So right off the bat, we'll excuse juror number 15. I'm fine with that. Okay. Did you have any full cause? And I think I agree with you. Let's go ahead and just excuse him. When I initially asked if there was anyone who couldn't be fair or any had issues, someone else raised their hand, but I didn't take notice. Did you guys by happen to? I think it was. There was 3. I know that. So let's go ahead and do that one. 3. Yes. Hold on. Okay. Do you have any more for cause? Just anywhere.
Oh, anywhere, sorry.
Just, I guess start with the first row. Do you have anything?
Yes.
Done or done and done? That's it? Yes, just for cause. Or did you have any others that you have any issues with? Yeah, I mean, of course, she was that. And I'm going to take. Okay.
14 and 32, same thing.
14 and 32.
The same reason.
The last stream. Hold on. Veneer. What's happening now is each of the sides gets peremptory challenges. What that means is that they get to strike nearly anyone on one of you guys for some reason that they didn't like. Nearly any reason, right? There are some exclusions, obviously, but you didn't look them correctly. You didn't give a right answer. So each of them get a certain number of strikes that they make. Okay. They get a certain number of strikes, defense get a certain number of strikes, and then when they're done, because I'm only giving them 5 minutes, they're going to give their strikes to us. We reconcile that with the other challenges that have been made, and with that, the first few get impaneled into the pool. Any questions? Okay, so give me 5 minutes, hopefully it's 5, and then you'll be out of here. Does anybody need a bus pass or anything of this nature? Okay, just one person? Anyone else? Okay. Work excuses? Okay, we'll have those for you too on the way out as well. All right, when you hear your name called, please stand and take a seat in the jury box. Oh, wait, hold on. Just your number. Just number, no name.
Okay. Juror number 4.
Can you please rise and come to the jury's box? You've been selected.
Juror number 10. Juror number 13. Juror number 14. Juror number 16. Juror number 17. And juror number 19.
All right, ladies and gentlemen of the jury, please rise. So everyone can be here tomorrow, correct? Everyone speaks English, right? You understand? We good? Haven't heard anything from you. Yes. Wonderful. I believe it or not, we've had it different. So, all right, will you please raise your right hand? Sworn. Do each and every one of you solemnly swear that you will true verdict or render in the case that's been sworn on to today? All right, you may be seated. Ladies and gentlemen of the jury, you're done. Thank you so much for coming. I hope this hasn't soured your experience, that you will show up for next service.
You're gonna get everybody outside, you know, do their work, I'll give it all.
We're done, we're done, we're done. Yes. Are you ready?
Yes, Judge.
Guys, please rise.
In cause number 2532700, in the Harris County Criminal Court at Law number 5, in the name and by the authority of the state of Texas, comes now the undersigned Assistant District Attorney of Harris County, Texas, on behalf of the state of Texas, and presents in and to the Harris County Criminal Court at Law number 5 of Harris County, Texas, that in Harris County, Texas, Odir Alberto Gomez Santa Maria, hereafter styled the defendant, heretofore on or about October 6, 2024, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, against the peace and dignity of the state.
All right, which the defendant pleads?
Innocent.
Okay, please be seated. Ladies and gentlemen of the jury, we are done with you guys for today. We will reconvene tomorrow back at 8:30 in the morning here. We have a jury room out there. I will have Deputy Echegoyen as your point of contact. If you have anything that you need, any questions, comments, anything, he will be your point of contact. You can ask him and we can always remedy any kind of situations. When you out there tonight, please do not do any independent research. Do not talk to yourselves about this case. Don't do any investigations, anything like that. We just want you to come in tomorrow, listen to the evidence, and then make a judgment call after both sides have closed. Anyone have any questions? Okay, so we're in recess for now. We'll begin tomorrow. As soon as all of you here tomorrow, 8:30, we'll begin the testimony, okay?
All right, for the jury.
Okay. Everyone, please be seated. Ladies and gentlemen of the jury, thank you so much for coming back. We didn't scare you off or you run away. We will try to be as efficient as possible because I know that your time is valuable. So with that, both sides will be afforded the opportunity to provide an opening. State. Floor is yours.
Morning, everybody. Thank you all so much for coming in this morning. What we have here today is a simple case.
Keep your voice up.
Thank you. What we have here today is a simple case. On October 6, 2024, Officer Metter, who you're from, in a traffic stop. Makes traffic stop, goes to the gas station, notices some signs of intoxication, and then begins an investigation. After that investigation, he concludes or he believes that the defendant is intoxicated. He takes the defendant to the station. A test is performed there, showing the defendant is intoxicated. All of this I will show to you, and after that, I will ask you to find the defendant. All I ask is that you stay with me. At the end, I promise you, I will make your trial very simple. Thank you very much.
Okay. Thank you, sir. Ben, would you like to?
I think so, Judge.
Okay. What's yours?
State told you this case is very simple. Officer sees car, pulls it over, sees signs of intoxication, does test, boom, intoxicated, here we are, right? That's what the state wants you to believe. What the state didn't tell you is what you're going to hear about why the stop happened. You're not going to hear an exact speed. You're not going to hear anything from that officer that tells you any kind of traffic violation was committed. That's what you're not going to hear. You're also not going to hear what his blood alcohol was at the time he was driving. You're not gonna hear that because they don't know that. You heard it. They stop him, they take him to the station, they do a test. The test is done well after the fact while he was driving. What the state will fail to show you and cannot show you is what his blood alcohol content was at the time he was driving. Not at the time he did his test, but at the time he was driving. That's an extremely important fact for you all to remember. You're not going to hear that. Not a single state witness is going to be able to give you that fact. And at the end of it all, after you hear all the evidence, after you see everything with your own eyes, we believe that the state will fail to meet its burden and that a not guilty verdict will be rendered. Thank you.
Vasquez, okay, state, you want to call your first witness?
Yes, Your Honor. The state calls Officer Michael Meadow to the stand.
Please.
Your Honor, the witness has not been sworn in.
Okay, sir, if you mind coming on up and raising your right hand, please. You solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God.
I did.
Any testimony you give will be the truth.
Yes, sir.
Please take a seat. I'm going to ask you to please speak loudly, clearly. If you hear the word objection, just stop until we've addressed it, and then you may continue this, okay?
Apologize for what I said.
That's okay. You've got a microphone there, so if you want to bring it up close, be loud.
Thank you, Judge.
Judge, the mic is not on.
I'm scared to turn it on because it always goes wacko. You want to, let's see if we can go without it at first, and then if not, then I'll fidget with it. Okay, please.
Thank you, Judge. Can you please say your full name for the record?
Michael Ray,
And what do you do for work?
Houston police officer,
How long have you been doing that?
7 years.
Can you briefly describe the training that you had for that?
It was a 6-month academy course, and an additional 6-month of field training. And then after that, you have yearly training to go on mandatory. Right.
Do you have any specialized training?
Yes, outside of the academy's SST or standardized field sobriety test training, I also took the ARIDE course, which is the advanced roadside and area driving enforcement.
What did you do in that course?
That is an additional refresh course for the field sobriety tests. It also teaches a few other tests like the Romberg balance, finger to nose, and lack of conversions. It also gives a little bit of baseline knowledge for what else can cause things such as HDM or where baseline stagnants to be elementary.
And you mentioned field sobriety tests. What are field sobriety tests?
Field sobriety tests are a set of tests by NHTSA, the National Highway Traffic Safety Administration, to establish whether or not someone is impaired while
What are those tests?
the horizontal gaze nystagmus, also known as HDN, walk and turn up, or you'll often see it produced at WAT, and one leg stand or OLS.
What is the HGN issue?
So horizontal gaze nystagmus is a test of a person's eyes. Gaze nystagmus is an involuntary jerk of the eye caused by presence, inhalants, or such demands that
What are the parts of that test?
it's a series of passes for the eye. First couple of passes are testing, you're looking to see whether or not the eyes track at the same pace or if they have equal size. It's not a fluke, but it's a good baseline. The next one's a lack of smooth pursuit. This is your first actual fluke. Beyond that, the next one goes to onset, or I'm sorry, distinct and sustained nystagmus, maximum deviation, meaning you're holding the stimulus all the way out to the side and having them focus on the stimulus for no less than 4 seconds to greater than 30. And then the last fluid is onset prior to 45 degrees. It's a way of seeing how much alcohol is in somebody's system based on how early the nystagmus sets in. There's one last set of passes for vertical. Vertical is not a fluid, but it's an indicator of how much alcohol that person's had for themselves.
And you mentioned the walk and turn test.
Yes.
What is that test?
Walk and turn, most people have seen it performed online on TV. It's the heel to toe test, where you have somebody stand in a given position, arms to the side, right foot in front of left touch heel to toe. You give them a series of instructions, take 9 steps down the line, a series of small steps around the turn the same line, 9 goes.
And then you mentioned one last test, the one leg stand test. What is that test?
One leg stand test is often looks like just a balance test. You have your arms down to your side, your foot up off the ground with a straight leg, you're looking at your foot and counting. Both of those tests are considered divided attention tests, so you're required to think and do at the same time, which for a non-impaired person should be normal.
And so after you complete each of those tests, what are you able to tell at the end?
The tests aren't pass or fail, they're a collection of clues based off the clues that you get for each test. You can judge someone's impairment. Most officers are looking for alcohol. It can also be other drugs. Generally you have other factors first.
Do you recall October 6th, 2024?
Yes, sir.
Were you on shift that night?
I was.
And how did you come to be involved in the incident we are here for today?
Trying to perform a traffic stop and that.
So,
Yeah, we're on it. We're getting you water now.
Down for
Okay, we got water.
Your Honor, would you let me to wait just a second for that water to come before you stop? I'm showing you what's been marked as State's Exhibit 1. Do you recognize this?
I do.
What is this?
This is the dash cam footage from my vehicle.
How do you notice that?
I reviewed it earlier today, signed for it.
And is it a true and accurate depiction of the events that?
Yes.
Your Honor, the state would request that State's Exhibit 1 be admitted to evidence.
Just tender, please, to defense so they can take a look at it for any
Tendering state.
objections.
I'm tendering State's Exhibit 1 to defense.
I have no objection, Judge.
Okay, it'll be admitted as states one. You said that's the dash cam?
Yes, Your Honor.
Okay, did you want to go ahead and publish?
Yes, Your Honor.
Okay, please do so. Ladies and gentlemen of the jury, we have 2 TVs. We have this one and this one. Feel free to take a look at whichever.
All right, Officer.
Yes.
What are we seeing here?
This is the dash cam view for
I'm sorry, what was that?
the dash cam view for my police. Purchase.
And what is the dash cam?
It's a camera mounted inside the vehicle, tracks audio, carries to your body cam, and tracks you.
I'm playing video. I am pausing the video at 10 seconds. Officer Meadow, what did we just see?
That was a silver Malibu that passed through the intersection southwest during this Belford.
And what did you notice about that vehicle?
It appeared to be going a little fast. It's the only vehicle on the road that night. And based on the speed related with the intersection, decided to go after it. See what else. See what there's any arch.
And what is the posted speed limit on that road?
35 miles.
And is that road in Harris County, Texas?
Yes, it is.
I'm playing the video at 10 seconds. I'm pausing the video at 35 seconds. Officer Meadow, what are you doing?
I'm trying to catch up to the vehicle, the Malibu. The taillights that you see just under the trees are that Malibu.
I'm playing the video at 35 seconds. I'm pausing the video at 1 minute and 0 seconds. And Officer Metter, after you catch up to him, what are you doing then?
So once I get up to enough speed, to catch up to him, I pace him for a brief period of time to see my travel speed versus his travel speed. So by keeping the same distance, I can judge that if I'm not gaining on him, I'm not going faster than he is, and if he's not coming back toward me, he's not slowing down.
You said pacing. You explained that a little bit, but can you generally explain what that is?
Matching somebody's.
And did you successfully match his speed during this?
Yes, 4 years, brake lights that second time I'm following for probably several hundred yards of that.
And what speed was that?
You can't see on this version of the dash cam because it doesn't have the graphic view to it, but about 64 miles.
And again, what was the posted speed limit in that area?
30.
And so is that speed greater or less than 35 miles?
It is 30 miles.
And then we mentioned pacing. Was your speedometer calibrated that day correctly?
Yes, sir.
How do you know that?
The vehicle is calibrated by our fleet coordinator, and it's also calibrated with the dash cams.
Do you need a quick break, officer?
That would be better.
I'm playing the video at 1 minute and 0 seconds. I'm pausing the video at 1 minute and 22 seconds. And officer, before I say anything about this part, just want to go back briefly. You said calibrated. What does calibrated mean?
It's measured and considered accurate for the vehicle travel.
So this part of the video, officer, what are you doing here specifically?
Reading his license plate, running it on it. Check the registration.
And what did that check change?
This was done in October of 2024, the registration expired November of 2020.
And so when you saw that, what did you decide to do?
Wait for the next large parking lot and pull over.
And is that what you did?
Yes.
I'm playing the video at 1 minute and 22 seconds. I'm stopping video at 1 minute and 38 seconds. All right, so officer, you, at this point, you made the traffic stop, correct?
Yes.
And where was that traffic stop made at?
Circle K over here. Same thing.
Is that also in Harris County, Texas?
Yes.
And before you make that traffic stop, will we see that street? Is that a public roadway?
Yes.
So you get to the gas station and you make the traffic stop. What do you do next?
Works vehicle.
And when you approached the vehicle, who was driving it? And when you say the defendant, can you please point out for the record and identify an article of clothing that the defendant is wearing?
In the skirt dressed in the gray button.
Your Honor, the state requests that the record reflect the officers identified the defendant.
Okay, it will so reflect.
So you approach the defendant's vehicle, what do you do after that?
Like on main track, stop request. Form of identification, inform them of the reason for the stop.
Without getting into the details of the identification, were you able to determine his name?
Yes.
And what was his name?
Alberto Gomez. Pardon my pronunciation.
Was there anyone else in?
No one else.
So it's fair to say that he was the driver.
Yes.
And then what did you notice about him when you first leave?
Upon my initial interaction with him requesting information. He had droopy eyes, glossy eyes, looking over of alcohol itself. Other than that, it appeared he was sleeping.
And so what did you do after that?
I requested Spanish speaking officer.
And those things that you noticed, you said about the defendant, what were those indicative of?
Generally indicate someone's been drinking, doesn't necessarily mean intoxicated at that point, but they at least had some form of alcohol.
And so what did you decide to do after that?
Wait for the Spanish speaking officer, connect our criminal history checks, I'm home, waiting to see if there's any moral return or anything like that. When the Spanish speaking officer gets there, proceed with the deal of the items.
You want to remain on approach?
Please.
I'm showing you what's marked as State's Exhibit 2, correct one.
I do.
What is it?
It's not probably working.
How do you know that?
I've reviewed it earlier.
And is it a true and accurate depiction of the events that were reported in?
Yes.
I'm tendering State's Exhibit 2 to Defense Counsel for inspection.
May we approach, Your Honor?
Okay, so just when you get there, mute it or turn the sound down. Mhm. You redacted.
Okay.
So let's play this. And then in the interim, if you can get a copy, a redacted copy, we'll put that in the record.
Okay.
Submit that to the record. So I'll admit this, subject to, well, I'll admit a redacted one into the record. We'll view this one for purposes of now, but if you can ask IT to get a redacted one or something. Or however. But I don't redact it now because I don't want to just have them sitting waiting. Let's do it while we're on break or something. Yeah, but we'll put the redacted copy.
And we can put that on the record outside the presence of the jury. Just
Yeah. Okay, right. You know at what time it is, right?
That's what I told you about. Okay.
Just, do you know the timestamp? Okay, so just let him know if you don't know that one. Perfect. Yeah, of course.
There's no published data in between.
Please.
And no objections, subject to.
Right, okay. So as far as my notes, I'm putting redacting.
Before I begin, officer, what are we seeing here?
The perspective from my pocket here,
And what are you and the other officers doing at this point?
rest, and it's,
I'm pausing the video at 8 seconds. I'm pausing the video at 13 seconds.
Your audio?
that's what we're trying to do.
All right, I'm playing the recording again from 0 seconds.
So I know because he doesn't speak a lot of English, let him know the reason for the stop. He's traveling 64 miles an hour to 35 and his registration expired November of last year.
La razón que te pagamos es porque estás manejando 64 millas por hora en un lugar donde tienes que estar manejando 3. También tu registro está vigilado el año pasado.
Sí, sí. Where's he coming from?
¿Dónde es?
No, de la casa. No, sí,
¿De la casa?
sí,
¿Dónde vives? ¿Cómo?
This foot going.
He says he's coming from home. ¿10 4?
Where you headed?
¿De a dónde vas?
I'm stopping the video at 1 minute and 20 seconds. Officer, what are you doing?
Establishing some of the basic information, address and phone number, and now we're asking kind of the preliminary question, where are you coming from, where are you going, what did you do when you were there, that kind of thing.
Are you noticing anything at this time?
In this particular case, because he speaks Spanish, I can't tell Spanish slurred words, anything like that, unless it's severe, so I didn't speak to that. But the more he continues to talk, the stronger the odor about all of this.
I'm playing the video at 1 minute and 20 seconds.
Entonces, apenas quedamos y repartimos lo que tenía que mudarse porque estábamos everything's included, he was up there right now. Entonces, got there was just like, you say he was helping us.
So he's coming from Cleveland or he's coming from South
También el
Side?
apartamento viene de Cleveland. Ya, pero me lo dejaron de Cleveland a él, ¿no? Que viene para acá porque aquí se me hace más para la base. Oh, so he's saying he came to Cleveland, he goes up there first, but he's trying out, he can't go down here because the gas is cheaper. And
Stopping the video at 2 minutes. And I'm muting the video for purposes previously discussed with council. I'm stopping the video at 2 minutes and 44 seconds. And I am turning the volume turn back up for purposes of the.
I'm sorry, say that again.
I'm turning the volume back on the video for the purpose of the jury being able to hear.
Belford and the other one that gets there in West Belford to come over here.
porque pasa las dos cosas, no. Es que yo fui con él a dejar su esposo, entonces no viene de la casa. Oh, no, yo digo de mi amigo, que tenía que mudarse a mi esposa, entonces yo le digo a él. Cuando primero le conté, le estaba preguntando de dónde venía. Oh, no, por eso le digo. Okay, so now he's saying, so now he said like, he was originally coming from the Sunshine, he was never coming from the Rock.
Okay, well, where does his friend live?
¿Dónde es su amigo? O mi amigo, mi primo, West Belford?
Yeah, where?
So he's saying his friend is West Belford.
Where else, Belford?
I'm pausing the video at 3 minutes and 32 seconds. So officer, we see you're asking a couple different questions here. What's kind of the purpose of this?
I'm comparing his initial statement coming from Cleveland, to his now statement I just left at my friend's house. Establishing direction of travel lines on that side of town, because originally he stated he was on our side of town for gas from Cleveland is quite the distance.
So what does that tell you?
Inconsistencies usually mean somebody's trying to not necessarily conceal something. Sometimes it's malicious and they wish to conceal. Sometimes they're just confused or they have inaccuracies because they're not. I mean, they're not cognitively fair enough to keep a consistent statement or to verify where they're coming to and from.
I'm playing the video at 3 minutes and 32 seconds.
So he's helping them move. Alright, were they doing any drinking while they were moving? Okay, so you had anything to drink? When was the last time you had something to drink?
It says early 5 to 6 p.m. You say you tried one over there. ¿Cuál es la verdad?
No sé, creo que es así, como media hora, no.
O sea, just.
Botella
o la?
Cans.
¿Y a qué hora fue tu última bebida?
Ya está, no más con a las 6.
I'm pausing the video at 4 minutes and 49 seconds. So officer, the last couple of questions we saw that you just asked there. Did you notice anything about those statements?
They're a little inconsistent. I didn't have anything to drink, and then I had something to drink at 5 or 6 p.m. The time to stop was about 2 o'clock at that point.
Does that tell you anything?
In most indication, trying to conceal, if not that they had anything, just the level of which they consumed that day.
I'm playing the video at 4 minutes and 49 seconds.
¿Y a qué hora tomó? ¿A qué hora tomó comer?
Hace un poco, una hora y media.
So they ate about an hour and a half ago.
Has he had any surgery recently on his hands, legs, or feet?
No, cirugías en sus piernas, caderas, no.
Pausing the video at 5 minutes and 26 seconds. Officer, that last question we heard that you asked, what was the purpose of that question?
It's to get an understanding whether or not somebody would have issues walking, standing, performing sort of any of the motion required for the 2 SMCs that require balance.
And what was his answer to
He
that?
said no.
I'm playing the video at 5 minutes and 26 seconds.
¿Tiene problemas en la casa? ¿Como se ha lastimado la casa?
No.
So he hasn't had any surgeries yet, he doesn't wear glasses or contacts.
Medication?
¿Toma medicamento? No. No medication. Hasn't had any head injuries at all.
Okay. Why did he have his driver's license yet?
¿Por qué no tiene licencia de manejo?
Oh, but the.
You want to maybe approach?
Sure.
Is this on the record?
I can't even hear you. I don't know what.
Can I just, with defense counsel?
Sure. Another redaction?
Yeah.
Okay. So same thing. Okay, just make note of the timestamp so that later when we do, yeah, okay.
I am resuming the video without audio for the jury at 5 minutes and 46 seconds. I'm pausing the video at 6 minutes and 14 seconds. And I am playing the video with sound for the jury at 6 minutes and 14 seconds.
Yeah. Parece.
I'm trying to fix them. Feet together, arms down to sides. You're gonna look at the red light. Keep your eyes and eyes open.
I'm pausing the video at 6 minutes and 30 seconds. Officer, can you tell me what you're doing here?
This is the beginning of the horizontal gaze and seconds test. I have him turned to face away from the roadway, so there's nothing moving behind him. And he's just got a building behind that. I'm using a pin light with my finger on this, it's not too bright. And that's just so it gives him something to focus on, as opposed to saying, follow my finger, follow this end of my pen. The red light makes a very apparent, symbol for somebody to look at.
And we've already established you may not understand English very well. How are you communicating with him, just for the record, to ensure that he understands your instructions on this test?
The other officer Ruiz, has been translating for me. As I give the instructions, he's going to translate for him to say.
And you just said, you kind of explain how you had him turn, why you had him turn that direction, but why is that important?
Things like strobing lights or vehicles passing by can kind of trick the eye into giving the false positive for the anti-seconds. If you're told to follow something with your eyes should be smooth, but if something then moves behind it, the natural reaction for a person is to look at that moving item and go back to the thing they're focusing on. So it'll give you a false positive, and we're looking to eliminate false positives.
I'm playing the video at 6 minutes and 30 seconds.
You're gonna fall without turning your head.
Yes, sir. Yeah. I'm going to investigate on. I'll be back in a few minutes. Alright.
Sí, solamente los ojos, no la cabeza. ¿Entendió? Sí. Ocho. Mira los grupos.
I'm pausing the video at 7 minutes and 40 seconds. Officer, you explained the HGN test in depth earlier, but just kind of refresh your memory, what are you looking for?
So the first two passes, again, orange blue, they're just making sure as I do move the same pace with each other, they just have different side achievements that indicate head trauma, that kind of thing. The next two passes are done the same way, from the nose out, approximately 2 seconds, and back to the other side. It's done twice per eye. You're seeing, now you're looking for whether or not the eyes are jerking while they move, or whether it's smooth, so that includes no lack of 20%.
And are you seeing that clue here?
Yes, sir.
And again, are we able to see that on the video? Or?
Yes.
I'm playing the video at 7 minutes and 40 seconds.
Not me, all right. We're gonna restart that one.
I'm pausing the video at 8 minutes. Officer, why did you ask him to restart that one?
He continues to look down, away, and then back at me instead of at Stu.
And why is that important that you did that?
This particular clue is called. The distinct and sustain nystagmus maximum deviation, meaning I have to bring it all the way out to the edge of his vision and hold it for a minimum of 4 seconds. If he doesn't continue to look at it, I can't count that clue because he's not looking at the stimulus term.
And are you seeing that clue at this time?
Yes.
I'm playing video at 8 minutes.
Yeah. Look at that. Don't want to go that way. Are you going to say something?
Cabeza recta y me hago
I'm pausing the video at 8 minutes and 45 seconds. Officer, we just heard you correct you and say, don't look past it. What is that? What are you doing there?
When you're doing field sobriety tests, you're asking somebody to look at something that's approximately 15 inches from their face. You can tell when somebody's eyes shift and their gaze looks down the way or it'll focus slightly out past you. So it's easy to tell when somebody's not looking at the red light that's right there.
And why is that important?
Again, by holding out maximum deviation, you're looking for that eye to jerk. If you're not at maximum deviation, and let's say they have a lower level of alcohol in your system, you're not going to see a jerk like you would on the next clue that's after this one. But that would cause them to look at it and have it, but if they look down the way, it's going to stop it because it's not pulling the muscle range.
I'm playing the video at 8 minutes and 45 seconds.
After you start down, just turn your head. Here goes. All right, 2 more for you.
I'm pausing the video at 2 minutes and 1 second. And so, officer, we just saw you finish that test up. What was the last part of that test?
There are two separate passes there. The first 2 provide from center to about 45-degree angles, about 4 seconds. So this clue is called onset prior to 45. By moving approximately 15 inches one way or the other, and counting the seconds that you go, 1 without, 2 without, 3 without, 4 without, it gives you an approximate angle of onset. And what you're doing is you're moving slow enough to see when that stagnant starts. And based on how close to the nose that is, the higher level up.
And what did you see during that phase of the test?
His started at about the 3-second mark, which indicates he's going to be at or above at the type of stuff.
And so after you concluded the horizontal gaze and nystagmus test, what conclusions did you make?
I concluded I had 6 of the possible 6 clues available.
What does that tell you?
That tells me he's likely impaired on some sort of depressant, most likely.
Your Honor, may I publish State's Exhibit 1 for the jury? I'm playing what's been previously marked as State's Exhibit 1 and entered into evidence for the jury at 2 minutes and 53 seconds. And officer, what are we seeing?
This is where I'm starting the next set of tests, the line turn is what we're beginning with here.
I'm playing the video at 2 minutes and 53 seconds. I'm pausing the video at 3 minutes and 45 seconds. Officer, what are you doing?
The initial setup here is the standing position. He's told to stay in the position I give him not to move until instructed. The first two available clues are somebody starting to walk too soon or not being in that position while the instructions being given. He's already broken his stance, one gotten back into position. Now I've just explained, I'm going to demonstrate it to him. That's the exaggerated arm slap down on the legs, is to say, I'm going to keep my arms down on my side and we'll look at my feet. I'm going to count out loud. I'm not going to stop until I'm finished. And I've instructed him that I'm going to do 3 steps in mine and he's going to do 9 in his.
And again, how are you communicating to him?
Officer Ruiz is standing, the gentleman's right.
And again, what is the walk and turn test designed to do?
So the right attention test is to make sure that your coordination, your balance, can coincide with you processing information at the same time. So I tell somebody to look and count at the same time, and then asking them to perform a task like walk, heel to toe. You're judging the brain's ability to split the tasks effectively, accomplish them.
And how many total clues are there?
There are 8 total clues.
I'm playing the video at 3 minutes and 45 seconds. I'm pausing the video at 4 minutes and 13 seconds. And officer, again, just to clarify, did you ask the defendant or did Officer Ruiz ask the defendant if they understood or if the defendant understood the instructions?
Yes.
And if he would have said no, what would you have done?
Re-explain them and ask them if you wish to have a demonstration on them.
And is it a clue if they ask to re-explain the instructions? I'm playing the video at 4 minutes and 13 seconds. I'm pausing the video at 4 minutes and 40 seconds. Officer, what clues, if any, are you seeing here?
He started before I instructed him to. That's where you see him telling him how to get back into that position before I indicated again. He misses all of the steps heel to toe, and he doesn't take the correct number of steps. He lands on his right foot if you're taking an odd number of steps. Knocking your left foot should be the one that's planted as you turn around. Additionally, when he turns around, he's not taking small steps to turn around. He's pivoting his foot and facing the other direction.
I'm playing the video at 4 minutes and 40 seconds. I'm pausing the video at 5 minutes and 0 seconds. So officer, again, what clues, if any, are you seeing from that portion of the video.
In this portion, you'd have to go back and let him perform that turn again, so the jury can see it, but he turns and then stops prior to beginning his walking. You're not allowed to stop during the test. We're also working with relatively thin line, so we'll give some leeway in terms of setting off the line, but as he walks back toward the vehicle, he walks at an angle and not along the same line.
And so previously we mentioned there are 8 total possible clues. How many clues did you see on that test?
7. The only one he didn't do is pull his hands away.
And what does that indicate to you?
A relatively high level of intoxication.
I'm playing the video at 5 minutes and 0 seconds. I'm stopping the video at 5 minutes and 25 seconds. Officer, what are you doing here?
In this particular instance, I'm explaining and demonstrating the test.
And what test is that?
This is the one-way state.
And what kind of test is that again?
It's another divided attention test. In this particular case, it's remembering to keep your foot off the ground, but maintain your balance while counting out loud. 1,000, 2,000, 3,000, doesn't matter if it's in English.
I'm playing the video at 5 minutes and 25 seconds. I'm pausing the video at 5 minutes and 51 seconds. And officer, just again for the record, did the defendant indicate to you that he understood the test?
Yes, sir.
I'm playing the video at 5 minutes and 51 seconds. Pausing the video at 6 minutes and 29 seconds. So officer, again for the jury, how many clues are there on the one leg stand test?
There are 4 potential clues.
Out of those 4 potential clues, how many did you see there?
3.
What are those clues that you saw?
He used his arms for balance, but he came away from his body greater than 6 inches. He put his foot down, and he also swayed and leaned one way or the other. And in this case, he kind of combined them all into one given set. He raised his arms, leaned to the side, and put his foot down, brings his foot back up, brings his arms back out away from his body to try to balance again.
And what does that tell you?
Also indicates a higher level of intoxication.
And so after you completed all 3 of the standardized field sobriety test, what did you conclude?
I concluded I had enough to detect arrest based on direct impulse.
And what did you do after that?
I had an officer read the DIC 24, which is statutory warning for it. DWI arrest.
Judge, we're approach.
Is it the same issue as last time?
Yes, Your Honor.
You know how to do it. Just keep doing it.
Thank you, Judge.
And we'll, when we take a break, we'll.
Your may I approach? Showing you what's been marked as State's Exhibit 3. Can you tell me what this is?
The top copy is the GIC 25, which is a suspension of the driver's license that has to be sent in DPS. The IRS. The second page is the signed GIC 24, the statutory warning, it's in Spanish. The last one is the GIC 23, which shows the police driver service on scene.
And what do you do with this?
That information gets sent to DPS following the arrest for DWI.
And is this a true and correct copy of that form that should use then?
Yes.
And officer, what exactly does this form tell you? What does it do?
Kind of admit it.
Yes, Your Honor, I apologize.
Okay.
I'm tendering State's Exhibits 3 for defense counsel inspection.
Just my prior statement, Judge, which we've already addressed.
As far as redactions are concerned?
Correct.
Sure, of course. Yeah,
Okay.
absolutely. Okay. It'll be admitted, subject to the redaction.
Thank you, Your Honor.
Okay.
And also, what's the purpose of the DIC 24?
The DIC 24 is a statutory warning. It tells the defendant I'm going to request a sample of red verbal and in most cases. Then it also gives them the ability to accept or refuse and the consequences for doing so, i.e. if they refuse to provide the sample I've requested, I'll literally have to be a warrant signed for it. And that way it's said.
And then how is this explained to the defendant that evening?
It has to be read verbatim off that page. So Officer Ruiz read it to him in Spanish. I requested a sample of breath and had him accept or refuse and sign first.
And what did he decide to do?
He accepted to provide a sample of his breath and then signed voices.
What'd you do after that?
I took him down to the joint processing center, which is the jail, where we have our DWI technicians.
And when you got to jail, what you did?
You walk into the jail, you sign him in, you go to an available DWI technician, form the ship them as your defendant. They have a mandatory observation period they have to do. So anytime you do breath, they can't put things in their mouth, chewing gum, vomiting in some cases, or a high level of intoxication. And the technician sits there and watches them for that 15-minute period prior to taking them into progress.
Based on everything that we've talked about today and your training and experience, were you able to come to a conclusion about whether or not the defendant was intoxicated?
Yes, sir, based on totality circumstances.
And what was that?
That he was not only intoxicated, but also highly intoxicated while driving.
State pass the motion.
Okay. Please.
Your Honor.
Yes. Floor is yours.
All right, Officer Metter.
Yes, sir.
So you just concluded your testimony by saying on your training and experience, you concluded him to be highly intoxicated, correct?
Yes.
But you also indicated during your testimony that clues and field sobriety test and clues in the HGN and odor of alcohol things like that, that those are generally signs that they've been drinking, but not necessarily intoxicated, is that correct?
Intoxicated can be any alcohol or other substances,
Okay. You understand it's not illegal to have a couple of drinks and still drive, right? Now, you also indicated that in your training and experience, based on your training and experience, but you said you took the A-Ride course, correct?
Yes.
When was that?
That was 2 years ago.
I'm sorry?
2 years ago.
2 years ago. You sure about that?
I'm not positive.
Would 2021 sound about right?
It could be even after I got the position as the DWI officer.
So in 2021, you took the A-Ride class, correct?
That's the information you have, is the I don't remember.
Okay. And how many hours is that course?
I think that one is 8 hours. I'm going to research correct. I'll do there for multiple days, but it's not 8, 16.
And since 2021, have you taken other education classes?
I've had one additional SSC refresh course since then.
Okay. What about other classes for non-DWI stuff?
Yes, every year we're required to take a minimum of 36 to 40 hours of departmental oriented, or departmental.
I'm sorry, how many hours?
36 to 40.
You need a moment?
No, as good as they'll be. Anything department mandatory, so this could include the active shooter courses, includes penal code updates, includes any changes to legislation, that's
Okay. So this is said to have occurred in 2024, correct?
Yes.
So in the 3 years that you took the A-Ride class, you only had one other class about DWI, correct?
one of the update courses.
Okay. But you've had hundreds of other hours of other types of education, correct?
Yes.
Okay. You remember taking a class in February of this year?
Not as I recall, no,
Computer operations?
not that I recall.
February 20th, 2025, you didn't take a computer operations class?
Unless it was a video that was taken at the station, I haven't attended anything in person yet, I don't believe.
And you indicated that the field sobriety tests are designed to have divided attention, correct?
The walk and turn, the one they say, yes.
Okay. And then your testimony, you indicated, you said that is relatively easy for a non-impaired person, correct?
Those were my words.
Okay. So it's not necessarily to mean that even an unimpaired person will get it perfect, correct?
Exactly.
Okay, so even somebody who is non-impaired or highly intoxicated, as you put it, could potentially have clues on a test, right?
Yes.
Okay. And you would agree with me, may I approach your honor?
Please.
You would agree with me that this is a natural standing position, correct?
It is, yeah.
Okay, this is not I can't even do it. This is not a natural standing position, is it correct?
It is not a natural standing position.
Okay, so this does require some level of balance, some level of muscle tone, things like that, correct? Okay. And you ask questions if he had any surgeries or anything like that, correct?
Yeah.
But you don't know if he'd had, maybe weak muscle tone in his legs, correct? No way of telling that, correct? You have no way of telling whether he had an inner ear infection or maybe some kind of balance issue or anything like that, correct?
Other than the screen question, no.
Okay. And then you would also agree with me that from this position, walking heel to toe is not natural, right? I've had a cup of coffee this morning and my hands went out, right? Okay. That is not a natural walking position, is it?
It's not.
This is a natural walking position, right?
It is.
Even if you're walking on a line, it's still going like that, correct?
Yes, sir.
So missing heel to toe is not necessarily a sign of intoxication, correct?
But it is a clue for this.
It's a clue for the test,
Yes.
right? But those tests are designed by somebody who just felt like making that test, correct?
It was on my NISA.
Okay.
I would work.
You would also agree with, may I put it in now?
Please.
You would also agree with me that standing with 1 foot up also requires some kind of muscle tone, balance, things like that, correct? Okay. So again, you didn't know if he had any kind of weak muscle tone, any kind of balance issues or anything like that, correct?
He expressed to us.
I'm sorry?
Not that he expressed to us, no.
Okay, but you didn't ask him either, correct?
No, we asked him that.
Okay. Those medical screens are surgery or head injury, correct?
Yeah, anything that is likely to cause impairment.
But you would agree with me that there are other things that could potentially affect the outcome of those field sobriety tests, correct?
Some, yes.
Same with the HDN, is that also correct?
There are various forms of HDM, but most are reduced or eliminated entirely, like use of stimulants. Now there's restricting on that.
I'm sorry?
Most are reduced or eliminated with use of stimulants, causing your eye to focus on the thing, which is why you have somebody turn away from flashing lights or move their vehicles, because they can cause that. Rotational, if you've been spinning in circles prior to the test, could also cause nystagmus. It would be reduced, but not eliminated, with use of stimulants. And there are other medical conditions, but how sure people normally tell you if you have afterwards.
Okay, so there are medical conditions, right?
Yes.
And you said an optometrist would usually tell you, correct?
Yes.
But that's not one of the questions you ask, is it?
Yes, not.
Wouldn't that be important to know?
We asked whether or not he has glasses or contacts, which would indicate whether or not he's been to an optometrist.
And he didn't tell you if he had glasses or contacts,
I
correct?
didn't wear it.
But you don't know if he'd ever been to an optometrist or had his eyes checked or anything, correct?
Yes.
And that's not a question you normally ask, correct?
It's not.
But it's important to know.
It's important to know, yes.
Okay, so on your dash cam, thing. So states exhibit 1. I'm gonna backtrack all the way to the beginning. Yeah, so. Oh, sorry, may I publish on?
Yes.
Okay, where are you right here?
I'm northbound on South Kessler.
On South Kessler.
Yes.
And what street is crossing in front of you?
West of.
West Duffer. Okay. Now, you would agree with me that he has a green light because you have a red light, correct?
Yes, sir.
Okay. And here you indicated that you felt he was speeding, correct?
Yes, sir.
But you don't have a side radar to be able to tell what his speed is, do you?
I do not.
Do you have a front radar to be able to tell what his speed is?
Yes.
I'm sorry?
Yes.
So you're just guessing he was speeding?
Based on my training experience.
All right, so about 8 seconds is when he passes you, correct?
Yes, sir.
About 9 seconds later is when you decide to pull out after him, correct?
I counted approximately 6.
So it's 17 is when you start pulling in, or 16, I'm sorry, 16. So from 8 seconds to 16, you good? From 8 seconds to 16 seconds, it's about 8 seconds, right?
Yes.
So he's got a little bit of a head start on you already.
Yes.
Now, we can see here that you have to make the turn and you start accelerating, correct?
Yes, sir.
So now we're at about 30 seconds, give or take,
Yes.
and about 22 seconds after he already passed you, correct?
Yes.
And you're still not up to speed. Right on. And we saw brake lights there, correct?
Yes,
And in fact, West Belfort is quite a bumpy road, right?
it is.
You can see your headlight bouncing.
Yes.
Okay, what intersection is this that you come up to here?
That's plain field.
Move it there. So now we're about a minute, 8 seconds. Minute 10 into him crossing in front of you, correct?
Yes.
So, do you know what the distance is from South Gessner to Plainfield?
Yes, sir, plain field's probably 0.2 miles. About a quarter mile.
Quarter mile, right? Okay. So, if it takes you over a minute, right, to go a quarter of a mile, that means you weren't doing 64 miles an hour, correct?
I had sped up to 64 miles an hour.
Okay, but it took him less than a minute or more than a minute to get there because he had a head start on you, correct?
He was already significantly further ahead. I maintained a higher speed in order to hit him from the point.
Okay, so quarter mile, and you claim you're doing 64, but if he was doing the same speed, he would have been past that intersection before you even caught up to him, correct? At a quarter mile?
If the light didn't ring.
Right, but we saw it turn yellow and then turn red, right?
Yes,
He didn't run the light, did he?
he did.
So you would agree with me that if his speed was the same as your speed, he would have had a much bigger distance on you and probably been through that light before it turned red, correct?
He hit his brake lights twice prior to that, so his speed would have been slowing also before that.
Okay, but you cannot say definitively what his speed was, is that correct?
I did not.
You didn't have it verified by any kind of radar or any other instrument or anything like that, correct?
No, sir.
So you were just guessing what his speed was, right?
Based on the speed of my cruisers.
Now, you don't speak Spanish, do you?
I did not.
So you were relying on Officer Ruiz to help you with the translation, is that correct?
Yes, sir.
And you indicated during your direct testimony that he gave inconsistencies about where he was coming from. Do
Yes,
you recall that?
yes, sir.
Okay, but you don't speak Spanish, correct?
No, sir.
So if we, in States Exhibit 2, I close, Your Honor. So this is States Exhibit 2.
R35 and registration expired November of last year.
La razón que te paramos es porque estabas manejando 64 millas por hora en un lugar donde tienes que estar manejando tu registro. También tu registro está ya por eso.
Did you notice right there when you indicated the reason for the stop, how he kind of shook his head?
No, sir. We're back home.
La razón que te paramos es porque estabas manejando 64 millas por hora en un lugar donde tienes que estar manejando tu registro. También tu registro está.
See how he kind of shakes his head and then gives you a look like, what are you talking about, Willis?
He looks from Officer Ruiz to myself as though he didn't do speeding, but then nods and says, yes, his registration is expired.
Okay. But registration, expired registration is not indicative of impaired driving, is that correct? And speeding by itself is not indicative of impaired driving either, is it? So in your opinion, in your training and experience based off what you just saw, do you believe that he was not challenging, but disagreeing with you on the fact that you claimed he was speeding?
At least on the speeding.
And that is, the speed is a fact that you used to stop him, correct?
No, I stopped him for his registration. His speed was caught my attention.
But you wouldn't have run his plate if you didn't think he was speeding, correct?
Like, when I didn't play this on the road.
Right, but you were going the opposite direction, so if he had just passed in front of you and you didn't think he was speeding, you would not have run his plate, correct? True. So the speed was a fact that you used to decide to go and run his plate.
Yes, how I intended.
Where's he coming from? ¿De dónde vienes? No, de la casa. Muy poquito de la casa. Sí, no le vienes. ¿Cómo? He says he's coming from home. ¿10, 4? ¿De a dónde vas? No, porque aquí, yo estaba mirando a un amigo, pero venimos de Cleveland, entonces hasta apenas llegamos y repartimos lo que estamos viendo mudarse, porque es.
Okay, so there at 129, he's talking about where he was coming from, correct?
Yes, sir.
Okay, but he's saying it in Spanish, so you don't understand exactly what he's saying, correct?
Luis initially in the case submitted said he's coming from home, and now it's telling Luis where he's coming from.
Well, he actually doesn't say his home, he says a home, or a house, right, is what he says. Right, okay.
Somebody coming from Cleveland, he was helping a friend out, and then he got.
So there he says he was coming from Cleveland and helping a friend out, right?
Yes.
But you don't know exactly what he's saying, you're just relying on Ruiz to tell you, correct?
Yes.
Later on down the road, I want to fast forward, so I stopped at about 133. Fast forward, that's too far.
Coming from Sunshine, he was never coming from.
Okay.
Where's his friend live?
¿Dónde eres los amigos? ¿A dónde amigo? Vive aquí en Woodbridge.
What were they doing at his friend's house?
Estaban ahí, estaban haciendo carrera, perdón. Oh, estamos hablando de ellos, okay.
And again, because you don't speak Spanish, you don't know what he's saying there, correct?
Yes, not until Luis says it's fine.
Okay. So here Ruiz tells you he was helping a friend move, correct?
I'm sorry, what are you saying?
Sorry. Wow. That wasn't bad. That was bad. I apologize. Here he's talking about, Ruiz tells you he helped a friend move, is that correct?
When Luis, yes.
Okay. But you don't know if that's what he said earlier in his statements, correct?
No, I have to rely on Luis first.
Okay, so if Ruiz didn't tell you the proper thing, you wouldn't know that, correct?
Now, started speaking up front, seeing this one very different.
Okay. And so with the fact that Ruiz was translating for you, you're relying on Ruiz to give you all that information.
Yes.
And then if Ruiz doesn't properly translate for you, then to you, that would indicate inconsistencies, correct?
It could, but that's not the inconsistency, I'm afraid.
What was the inconsistency you were
He
referring
said
to?
he was driving to that side of town, so that he gasped and she relaxed from Cleveland.
Okay, again, you were relying on Ruiz to tell you that, correct?
Yes.
All right, so I'll reserve my questions on that for Ruiz. But again, you would rely on somebody else to tell you what he was saying and hope that they're properly translated, correct?
Yes.
In your 7-year career, am I right, 7 years?
Yes.
In your 7-year career with Houston Police Department, how many DWI stops have you made?
I don't know the exact number, more than 100.
And out of those 100 or so, how many people did you arrest for driving while intoxicated?
Without the exact number, I couldn't tell you. I know, but others that didn't meet the criteria of driving while intoxicated.
And Were there ever some that you arrested, but then maybe later turned out they weren't intoxicated?
I've had a few that blew under the legal limit .08, and we have, jail orders that prescribe what's in those situations.
So again, the clues that you observe aren't necessarily indicative of the level of intoxication. It's just based on what you think. Is that correct?
No. The number of clues specifically in HGN can indicate a higher level of intoxication based on what's there. HGN is always done in the same order because you can't have onset prior to 45 without maximum deviation. You can't have maximum deviation without maximum pursuit. They don't go out for it.
Okay, and so you previously testified, while I was asking you questions, that there are other factors that can cause nystagmus, correct?
Yeah, rotational stroking lights, moving vehicles, that kind of thing.
Medical conditions, eyes, things like that. So the 6 of 6 is not indicative of high level of intoxication if there are other factors present, correct?
Without other clues.
And then those other clues were,
What's the totality of circumstances?
the walk and turn, correct?
Well, other clues in the sense that there are other tests, yes, but other clues in the sense that what you smell on scene, what you see in the eyes, response, movements, that kind of stuff.
Okay, but you would agree with me that alcohol actually does not have a smell, correct?
Different types of alcohol have different smells. You can tell the difference between a spirit and a beer. Most people know the difference between say, whiskey and Bud Light.
But you couldn't tell what, if anything, he had to drink, correct?
It smelled like beer. I couldn't tell you what brand of beer.
And again, not illegal to have some fajitas, as he indicated, and drink a beer with that, correct?
It's not.
And even if one, maybe 2 beers, though maybe not intoxicated, it would still have that odor, correct?
Yes. And that's what the tests are designed to screen.
Within the tests, which are fundamentally flawed, correct?
No, sir. It's done quite a bit of research around since the 80s.
So again, may I approach you, Your Honor?
Please.
This is what NHTSA says is appropriate to do for a test, correct? Right. And then you said he started before you told him to, correct?
Yes.
Isn't it possible that some people sometimes are eager to just get the test over and done with so they can go home?
That's possible.
Okay. So not necessarily a sign of intoxication, correct?
As an individual clue.
Okay. And again, not hitting heel to toe, this is not a natural walking position, correct?
Correct.
So not necessarily a sign of intoxication,
As
correct?
an individual clue, no.
Okay. Wrong number of steps. You said he took too many steps.
We took a few steps. He took 8 steps instead of 9.
Okay. And then you said he made the wrong turn. How many times do you demonstrate the wrong turn or the turn?
I demonstrated immediately before they did the test themselves.
Okay. But that's still, they still have to take 9 steps before they make that turn, correct?
Yes.
Okay. So you said small steps, didn't do the small steps to turn around. Again, when somebody turns around when they're walking, when they turn around, this is a more natural movement, correct?
It is.
Not this, like a penguin?
It is.
Now, he didn't fall over, correct? He didn't use his arms for balance, correct?
Not on that test. No.
He wasn't stumbling, he wasn't tripping over anything, nothing like that, correct?
Not on that test.
The only clues that you saw were clues that are just unnatural human movements, correct?
No, sir. I saw the clues that I described in the test for him.
Right, which is
He was
not heel to toe.
He was instructed to take 9 heel-to-toe steps. He did not. He was directed to turn around in a specific way. He did not.
Okay. But again, those are not natural movements, correct?
But they are the instructions.
I get that they're in the instructions. I'm asking if they're natural movements. How many times have you done the field sobriety test?
Every time I've done any sort of arrest.
Okay, so every time you've done an arrest for a DWI, you've done hundreds of DWI arrests. You've done this test 100 and something times, correct? Plus the times that you did it when you were there,
Yes,
correct? So you don't know, I mean, it's not like a person sits at home and says, I'm gonna practice the field sobriety test and learn how to do it and make sure I have it memorized, correct?
correct.
They hear it one time from you and you didn't even relay the instructions in Spanish, correct?
I didn't know.
And you hope that the instructions were relayed appropriately, correct?
Yes,
And then that one time, that 5-10 seconds that you show it to them, you expect them to remember it while they're in the presence of police officers with flashing lights behind them in a stressful situation and do unnatural movements. That's what you're saying you expect them to do?
I expect them to perform the test yet.
Okay. I'll pass the witness.
Okay, State, you have any follow-up?
Yes, Your Honor. Officer, how many people have you pulled over for speeding in your career?
I couldn't tell you.
Could you give an approximate number of how many you pull over per week?
No.
Could you,
So let's not, fishing expedition, keep it nice, keep it neat.
is it fair to say that you pull over a lot of people for speeding?
A fair amount, sure.
So again, what initially drew your attention to the defendant's vehicle?
I'm familiar with that intersection. Our station is less than a mile south of that. So you get a general sense of the low track. And when somebody passes in front of you, that's that expectation of generally is indications.
Now, at that point, did you make the decision to effect a traffic stop?
Yes,
So what did you do after that?
I caught up to the vehicle, and when he stopped at the light, I ran his plate to see if there was anything else I could work.
And when did you decide to effect the traffic stop?
After finding his registration expired.
Did you decide to do that at any point before you found the registration was expired?
Yes,
Now, let's go back to the standardized field sobriety test we talked about. Was the HGN the sole reason you determined he was intoxicated?
it was not.
Was the walking turn the sole reason you determined he was
It
intoxicated?
was not.
Was the one leg stand the sole reason that you
Yes.
chose? What were the reasons and what facts led to your determination that the defendant was intoxicated?
So the totality of all the clues presented within the field sobriety tests, in addition to the odor of alcohol, the glossiness of the eyes.
Now, let's talk a little bit more about the field sobriety test. Are they supposed, specifically the walk and turn and the one leg stand, are they supposed to be natural movements?
They're not,
Why?
because natural movements wouldn't give you an indication of someone's balance or ability to pay attention.
And are these certified tests?
They are certified tests.
And who certifies those?
National Highway Traffic Safety Commission,
Are they widely used?
everywhere in the United States.
And per the translation from Officer Ruiz, did you have any indication whatsoever from the defendant that he could not complete the test as instructed?
Yes,
And you said it before, but what happens if the defendant indicates to you that he doesn't understand the test?
I'll re-explain everything.
Do you hold it against him? Does it count as a clue?
No,
Was he free to ask for a re-demonstration of the test?
Absolutely.
Did he ask for that?
He did not.
And so, officer, let me just touch on this just a little bit more. If you didn't have inconsistent statements from the defendant, per the translation from Officer Ruiz, would you still have continued your investigation?
Yes,
Why?
because of the odor of alcohol.
State that's the really show.
All right,
Briefly, Your Honor.
please.
So just based on the odor of alcohol, you would continue your investigation, correct?
Yes,
But again, 1, 2 beers, you're gonna have an odor of alcohol, correct?
yes,
And as far as the glassy eyes are concerned, and again, not illegal to have 1 or 2 beers and drive, correct?
correct.
As far as the glassy eye is concerned, he told you that he was coming from Cleveland to help a friend move, correct?
He did.
So is it possible that he could have been up for several hours prior to getting pulled over by you?
Objection, Your Honor. Speculation.
I'll rephrase it, Judge.
Okay.
So you indicated in your body camera that Cleveland was quite a distance away, correct?
Yes,
So probably an hour or 2, maybe, to Cleveland?
I haven't driven there recently, so I can tell you.
And then, based off of that, driving from Cleveland, helping a friend move, does it make sense that, or would you have reason to disagree with me that he could have been up for several hours at that point?
Objection again, Your Honor. Cause for speculation.
Answer, if he knows.
Without him specifying how long you've been waiting, I have no idea.
But you didn't ask that question, did you?
Yes,
So if somebody had been awake for several hours, they could have glossy eyes, correct?
they could.
So again, not necessarily a sign of intoxication, right?
By itself, no.
And then the state followed up by asking you about the speeding. But you testified earlier that you could not tell exactly how fast he was going, correct?
I did not.
So you have no idea whether he was speeding or not.
We go generally past from that intersection only. Yes.
Okay. And you said you're familiar with that intersection and you can tell how fast somebody's going, or you can generally gauge how fast somebody's going by the flow of traffic, correct?
Yes,
How many other cars were on the road?
no other cars.
So there was no flow of traffic to be able to tell, correct?
But that doesn't change the fact that I've been through that intersection.
Okay, that was my question, sir. My question was, there was no flow of traffic, correct?
And the flow of traffic.
And so with no flow of traffic, you have no other vehicles to gauge your perception on, is that correct?
That's not enough.
So, and again, just to make sure I'm clear, you testified earlier that what drew your attention to him was what you perceived to be speeding, correct?
Yes,
And then when you catch up to him, you run his plate, and then that's when you find the expired registration, correct?
yes, sir.
And then based on the expired registration is why you decided to pull him over, correct?
Yes,
And then when you told him he was speeding, he seemed to question your speeding, your perception of speeding, correct?
that's correct.
So would it be fair to say that he was challenging, not necessarily challenging, but disagreeing with what the reason was why you stopped him?
He may have been from the speed.
And the speeding is a fact that you used to run his plate to pull him over, correct?
It's what how my initials and
Nothing further, Judge.
Okay. All right. May this witness be excused.
I would like subject to recall, Judge.
Okay, officer, if you don't mind, you're done for now. If you don't mind, just taking a seat in one of the witness rooms and do not leave just yet, please. Let's take a break. Okay. All right, ladies and gentlemen of the jury, we're going to take a brief recess, give you time to handle any matters you may need to handle. We need to handle little business matters as well. I'll try to bring you back as quick as possible so we can continue, okay? Please,
All right,
you go with
Jerry.
Deputy Miranda. All right, we are back on the record in the trial case. And after speaking to both state and defense, both of you guys have come to the agreement that you are ready to release Deputy Metter, not subject to recall anymore.
Correct, Your Honor. That's correct, Your Honor.
Okay, all right, so we'll let him go. And
Thank you, Your
then,
Honor.
I guess we'll start here momentarily. Okay,
Thank you, Your Honor.
thanks. Okay, so we're back on the record in the trial case, and before I ask the state to call its next witness, Ray, did you have something that you wanted to do?
I do, Your Honor, and just wanted to ask the court, I would file an oral motion to suppress any evidence obtained from the traffic stop. I don't believe there was probable cause for the traffic stop. Officer Metter indicated that he could not tell how fast he was going, that it was less than a quarter of a mile before to the next light where my client was stopped. It took over a minute for them to get there. Therefore, whatever speed Officer Metter perceived is inaccurate. He even indicated so himself. Also, Judge, at the same time, Officer Metter said that if not for his perceived speeding, he would never run by the client's license plate. And I don't believe with him not running the license plate, he even indicated that had he not perceived him to be speeding, he would have never ran his plate and therefore would have never found out about the expired registration. And on top of that, the officer also testified that the expired registration in and of itself is not indicative of driving while intoxicated. I don't believe there was probable cause to pull him over based on the inability of the officer to say how fast he was going. And I don't believe that without that reasoning, he would never run his plate. If he would never run his plate and found out the expired registration, he would never got into the field sobriety test and we would not be here. So I'd ask for all evidence to be suppressed based on the fact that the officer did not have probable cause to even run his plate or stop him to begin with.
Okay, response?
Your Honor, the state would offer that there are several arguments to be made here. The first of which is that the officer's suspicion was initially triggered based off of what he believed to be speed. He then follows that up with pacing, a method that is commonly used and applied by law enforcement. And he also verified that his speedometer was sort of calibrated that day. Because of that, he was able to pace the defendant at a speed that, even if it was not the speed of 64 miles an hour that the officer testified to, he knew that it was at least above the posted speed limit, which on its face is enough for the officer to initiate the traffic stop. However, the officer did not stop there, he went further. And even if that part of pacing is not accepted by Your Honor, the next part that the state would argue would be that the officer's initial suspicion was triggered. He continued to have suspicion of the vehicle. And then once he got up to the vehicle, he ran the registration. As he testified, he can do on any vehicle, as is commonly accepted. That once he found that the registration was expired, he then initiated a traffic stop at the next possible moment to do so, which, because of that expired registration, on its face is sufficient for the officer to initiate the traffic stop.
Okay, I get it. I'm going to deny your motion. I mean, I think that there's enough to go on. You know, officers, the training and experience, it's a 30-mile-an-hour road. They know when it's faster than that, and then they can run the license plate for, I'm going to deny the motion. Sorry, Ray.
Your Honor.
Okay. State, are you ready to call your next witness?
Yes, Your Honor.
Okay.
All right, for the jury.
Okay. Ladies and gentlemen of the jury, we're going to continue now with the state's next witness. Everybody please be seated. Who's your next witness, State?
State calls Officer Nicholas Ruiz Flacwen to stand. Your Honor.
If you mind, Deputy Miranda.
Your Honor, this witness has not been sworn in.
Okay, Deputy Reeves, come on up, raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I swear.
Any testimony you give will be the truth.
I swear.
Please take a seat. And I ask you to speak loudly, clearly. If you hear the word objection, just stop until we address it, and then you may continue. Okay? Okay, stay, please.
Thank you, Judge. Officer, would you please state your full name for the record?
Nicholas Ruiz.
And what do you do for work?
I'm a police officer with the Eastern Police Department,
How long have you been doing that for?
approximately 2 years.
And what kind of training do you have to be an officer?
You have to go to the Eastern Police Department's Academy for approximately 8 months.
And what does that involve?
It involves training, case law, criminal code of procedure, things like that.
And officer, in your experience, have you ever been involved in a DWI investigation?
Yes, sir.
Can you approximate how many DWI investigations you've been involved in?
Numerous amounts.
And officer, how many languages do you speak?
I speak 2 languages,
What languages are those?
Spanish and English.
Which language was your first?
Spanish.
And have you continuously spoken Spanish your entire life?
Yes, sir.
Do you frequently use Spanish in your job?
Yes, sir.
Have you ever had problems with people understanding your Spanish?
No, sir.
If they do they indicate that to you?
Yes, sir.
And how would they indicate that to
By asking me to repeat what I said.
you? Do you recall October 6th, 2024?
Yes, sir.
And were you on shift that night?
Yes, sir.
How did you come to be involved in the incident we are here for today?
Officer Matter requested for Spanish speaking officer, and I checked on it.
And when you got there, what'd you see?
I observed the defendant to be in a vehicle, and then Officer Matter asked me to step out and stand.
And when you say the defendant, who do you mean?
And I said it was a Christian. On the photo.
You understand that in the record reflect that the witness has identified the defendant.
Okay, it will reflect.
Thank you, Your Honor. All right, so you get to the vehicle.
That's right.
What did you notice in your interaction with the defendant?
Upon making contact with the defendant, I observed his speech be slurred. I could smell alcoholic breath and committing from him.
And you said his speech was slurred.
That's right.
And you're all right, and what did you do after that?
At that point, Officer Matter advised me to translate what his instruction for the SFPs for English Spanish.
Before that, did Officer Metter have you translate anything else?
That's right. He asked me to translate the probable cause for the son.
And after you translated the probable cause, what did you do?
I advised him, Officer Matter asked me to translate the SFPs.
And when you were translating the SFSTs, did you encounter any problems in translating those for the defendant?
No, sir.
How do you know that?
I repeatedly spoke to the saying to the defendant he understood, and he shook his head, saying yes.
At any point, was there any indication to you that he did not understand what you were saying?
No, sir.
All right, so after the SBST, what you do?
I read in the DIC 24 or the DIC 24, the statutory warning against family.
Okay. And did he indicate to you that he understood?
Yes, I asked him and he understood.
And what did the defendant say after you read the DIC object?
I asked him for a sample records of which he consented. So he asked me why he was being arrested. I told him that he was being detained.
And did you have any other involvement after that?
No, sir.
Senator, may I approach?
Yes.
I'm showing you what's marked as State's Exhibit 3. Is this the form that you indicated you read to me?
Was any of the
Yes, you can.
yes. Yes.
To clarify for the record, what form is this?
The duration of period of suspension. Yes, it was.
And you confirm that you read these to him.
Yes.
And he understood it when you read it to him. State that's the ledger.
You mind, Dr. Johnson?
Please.
So you're saying this is the form that you presented to him, read to him, correct?
Yes, sir.
That one only? I call it, Your Honor.
Yes. What, is it in evidence? Which form is that?
Oh, I'm sorry, this is State's Exhibit 3.
As far as I could see, only the DIC 25 is in evidence now, right?
It was the entire packet.
Sorry?
Your Honor, the entire packet was,
Okay.
I believe, so it's marked as State's Exhibit 3.
Okay. Okay, so this is the form you read to him, correct?
Yes, sir.
What does that form explain?
The duration of the periods for suspension. So just based on whenever you commit the first crime, like 180 days, 2 years.
Okay. Doesn't say anything about his rights or anything like that, correct?
No, sir.
Doesn't ask him for a breath sample or anything like that, correct?
No, sir.
All it talks about is his license suspension, correct?
Yes, sir.
Now, you indicated that you observed slurred speech, is that correct?
Yes, sir.
Okay. Would you have any reason to disagree? You weren't the lead officer, correct?
No, sir.
Who was the lead officer?
Officer Madden.
Would you have any reason to doubt Officer Metter's observations and opinions?
No, sir.
Is he more senior to you?
Yes, sir.
So if Officer Metter testified that he did not observe slurred speech, somebody is wrong, correct?
Not exactly, sir.
Okay, well, Officer Metter, if Officer Metter testified that he did not observe slurred speech, would Officer Metter be wrong, or would you be wrong in observing slurred speech?
I observed slurred speech. I'm not going to testify to what you observed, but I observed slurred speech.
But you have no reason to doubt what he saw and what he testified to, correct?
That's correct.
Now, as far as you know, you've never spoken to my client before, right?
No, sir.
So you don't know what his normal speech patterns are, correct?
No, sir.
So you don't know if that's just his normal speech.
No,
You don't know if he has a speech impediment, correct?
no, sir.
Maybe a breakdown.
Say it again.
I've never burned the declaration just yet. I haven't burned down around.
Okay,
Can we play the declaration or something?
sure. I mean, as long as you're okay with it, yeah.
That's.
You mean how? Well, what is it for?
This is the body cams.
Okay, you want to do it? Just kind of show it to them, I guess? Like put it up on the podium here or?
Or we can put it through.
Oh, there?
Yes.
Oh, okay, yeah, yeah.
Just.
I don't care. Yeah. As long as you're okay, both parties.
This is the version that's gonna go back. All right, so this is State's Exhibit 2. Yeah, State's Exhibit 2. Okay, so that's you right there, correct?
That's correct.
So I don't get to speak a lot of English. But the reason for the stop was traveling 64 miles an hour to 35 and registration expired November of last year.
La razón que te paramos es porque estabas manejando 64 millas por hora en una lugar.
Okay, right there, what did you just tell him?
I told the probable cause for stopping,
And what exactly did you say was the probable cause for the stop?
that he was driving 64 miles an hour in the 35.
Okay, did you see his reaction when you told him that?
No,
Registration expired November of last year.
La razón que te paramos es porque estabas manejando 64 millas por hora en una lugar.
that's not correct.
Okay, what was his reaction there?
Surprise.
Would it be fair to say that it seemed that he was disagreeing with what Officer Med was saying or what you were translating?
That's correct.
Where's he coming from? No, de la casa. Uno quiso,
¿De la casa?
sí, no le vio como son. This was Johnson.
He says he's coming from home. We're coming from Cleveland, he was over for now.
Entonces, lo que tomé como base porque estábamos.
He said they're coming from.
What was he saying there?
That he was helping someone to move.
Helping somebody to move, correct? Okay. But you didn't tell Officer Metter those words, did you?
I said, he was helping a friend move.
Sorry?
I said that he was helping a friend move.
At this point, you said that?
But
Entonces, apenas llegamos, lo repartimos, lo que tomé como base porque estábamos.
He said they're coming from Cleveland, he was over for now.
Entonces,
Got there, they're just like.
yo estaba ayudando, no.
So he was helping for that.
He's coming from Cleveland or he's coming from South Florida? Yeah, pero hablando de allá, me fui a dejar a él, ¿no? Estoy viendo para acá, aquí se me hace más a la base.
Oh, so he's saying, he came from Cleveland, he was hoping to start, he's trying out, you know, go down here because the gas is cheaper.
Okay. You heard him say earlier that he was going to his friend's house, correct?
that's correct.
You didn't translate that to Officer Metter, correct? At this point? You just said he came down here for gas is cheaper, right?
Well, he said he was helping a friend move in Spanish, and I told him that he was coming from Cleveland, they was coming from there, and that he came from here. The whole city that he provided was very.
I'm not, the state can ask questions if they need to. What I'm asking you is, your translation was not entirely accurate as to what he was saying, correct?
Are you referring to, was it verbatim?
Yes.
It wasn't. It was paraphrased.
It was paraphrased, correct?
That's correct.
So some things were left off, correct?
That's correct.
And then later on. Okay, so. Just to make sure I'm clear, you didn't translate verbatim, you just gave summaries of what he was saying to you, correct?
I paraphrased what you're saying.
Paraphrased. Do you feel that it would be important, especially for Officer Metter, who's the investigating officer, to have exact translations so that nothing is missed?
That's correct.
And do you feel it should have been, if things were missed, and Officer Metter does, as far as you know, Officer Metter doesn't speak Spanish, correct?
That's correct.
Yeah. So if you didn't say certain things at all times, is it possible that you may have relayed inaccurate information to Officer Metter?
That's not correct. I just paraphrased the translation.
Okay.
I didn't say anything that was incorrect, just basically what you said.
But you didn't say all of the facts, correct?
That's correct.
Okay, so if some facts were missing, it's possible that Officer Metter may have thought that there were inconsistencies in his statement, correct?
That's correct.
Nothing further, Your Honor. Okay. Anything further?
Yes, Your Honor.
Be brief.
Yes, Your Honor. Does Officer Metter know Spanish?
No,
Can you tell if somebody has slurred speech, generally speaking, if you don't know the language?
that's correct.
So let me clarify. Is it hard to tell if someone has slurred speech if you don't know the language?
No, sir.
It's not hard to tell if you don't know the language.
No, sir.
Alright. Your Honor, may I approach?
Sure.
Showing you what's been marked as State's Exhibit 3. I'm showing you the first page of what's been marked as State's Exhibit 3. Did you read this for the defendant?
I'm gonna object, Judge. I think this has been answered.
Has he already answered that he has done this?
Judge, defense counsel led or asked several questions that I believe need to be clarified for the jury on exactly what he read to the defendant, especially.
Has he already testified that he's read this?
He testified that he read the periods of suspension. That's what he testified that he read, and I believe that that's his testimony. The state going back this question has already been asked and it's already been answered.
No, because this is this is not the DIC 25, right? This is the DIC, which
one?
one?
Your Honor, I would like to go through, there's 4 pages here. I'd just
Right.
like to go through and clarify exactly what pages and what he read to the defendant.
Okay, overruled.
And Judge, my objection to that is this is the same exhibit. He had an opportunity to view that exhibit when they were asked and after, when he was presented with it. He went through and he indicated both on direct and cross-examination.
I don't want to limit his direct though, you know, okay, overruled. You may continue.
Did you read this page to the defendant?
Do you mean like, is it saying something?
Yes, just did you read it?
Usually was a big one. Yes, sure.
Okay, okay, so you read what's marked as page 2 of State's Exhibit 3, correct?
Yes.
Okay, you're indicating to me that you read what's marked as page 3 of State's Exhibit 3, correct? Okay, did you read anything off of page 4? Would you ever do?
No.
Why not?
Because I'm not the Western officer.
Just to clarify. Okay, so I'm showing you what's marked as page 2 of State's Exhibit 3. Did you read this to the defendant?
No.
You just testified on cross-examination that you read that to the defendant.
Yeah, I got confused with the other one.
Okay. I'm showing you page 3 of what's marked as State's Exhibit 3. Are these the statutory warnings
Yes.
that you read?
Yes.
Did you read those to the defendant?
Yes, sir.
And what does this say? What is on here?
Basically why he's being detained. And then we asked him for a sample of breath and what are the consequences of him saying no to a sample of breath and or blood.
And what did he say when you asked him?
I said, he said it's not very long.
Is that visible on here on this form?
Yes, sir.
Where does it say?
Right there, right where he signed or where I'm asking.
Where does it say that he consents?
Right in the bottom where it says consentimiento, right next to it says firm signing, that's where he signed right next to it. And where that checkbox is him saying that he's giving consent to the taking of his breath.
And is that his signature?
That's correct.
Now, officer, you mentioned you were paraphrasing a little bit. How often do you use Spanish in your job to translate for investigations?
All the time.
When you're translating, do you translate what is being said verbatim?
On some occasions I do, on some occasions I translate paraphrase.
On the standardized field sobriety test, did you translate them verbatim?
I don't know.
Why, when you're translating something, would you not translate it word for word?
Because the translation from English to Spanish is different. Some words wouldn't make sense.
Were the general instructions the same, or were the general instructions that you gave the same in Spanish that Officer Metter was instructing in English?
That's correct.
And was that true for the entirety of your interaction in this instance?
That's correct.
Nothing further from the statement.
Briefly, Your Honor,
Yes, sir.
but that's actually not true, correct, Israel? Correct? It's not true that you translated verbatim everything, correct?
That's correct.
So when the state just asked you if that was what you did for the entirety of the investigation, that was the false answer, correct?
No, sir.
Well, they asked you, did you translate verbatim for the entirety of the investigation? You said yes.
He asked me in some instances for investigation. I'm not sure if he asked me for this case specifically.
Oh, no, he asked you for this case.
I'm not about that.
So is that because you got confused again?
No, sir.
When you got confused, you said you got confused as to which form you read.
He didn't ask me about translate verbatim. I told you before I paraphrased what he was saying.
Okay, so it's possible you paraphrased the instructions as well, correct?
No, sir.
And what about the DIC form? You testified on direct and on cross-examination twice that you read him the suspension period page, correct?
That's correct. I got confused.
Well, you would agree with me that there's a big difference, even in Spanish, between something that says these are the periods of suspension, these are your rights under the law, correct?
That's correct.
And as far as different languages, in understanding slurred speech or noticing slurred speech, it's possible that even if you don't speak the language, you can still tell if somebody has slurred speech, correct?
That's correct.
Nothing further, Your Honor.
Great. May this witness be excused?
Yes, Your Honor.
Yes,
All right. You're done. Thank you so much for testifying. Stay safe out there. Do you have one more witness?
2 more witnesses, Your Honor.
Guys, you want to go through one more? What say you? Keep going? Lunch isn't here yet anyway, so. Okay, State, call your next witness, please.
State calls Donald Varner to the stand, Your Honor.
Come up, sir.
Your Honor, this witness has not been sworn in.
Okay. If you'd be so kind to raise your right hand, will you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Any testimony you give will be the truth.
Yes, sir.
Please take a seat.
Thank you.
Please speak loudly, clearly. If you hear the word objection, just stop. We've adjusted, then you may continue. Okay,
Hey, Judge.
you may
Can you say
continue.
your full name for the record?
Don Varner, V as in Victor, A-R-N-E-R.
And what do you do for work?
Work for the city of Houston as a DWI technician.
And can you briefly describe your education and training you had to have to hold that role?
Yes, I went to the HP Academy for standard field sobriety test with SSD. 40-hour class with continuous education with the state of Texas to become a top lighter and go to the law school.
And how are you licensed?
Wait, whatever.
How are you licensed? Are you licensed to operate an intoxicator?
Yes,
And how are you licensed?
with the state of Texas, take an exam every year and at least a minimum 5 breath tests a year,
And how long have you been licensed?
10 years,
And what instrument are you licensed to operate?
9,000.
Do you have your current license?
Yes,
Have you had any other special training or attended any special courses pertaining to your duties as an intoxicator operator?
yes.
What kind of training?
A standard field sobriety test
Keep your voice back.
and the longest.
And just to clarify, do you presently hold a license from the Texas Department of Public Safety as a qualified operator of the intoxicator industry?
Yes,
And how often must your license be renewed to retain or to remain a qualified operator?
every year.
And when were you last licensed?
October the 31st of 2024.
And was your license current on October 6th, 2024?
Yes,
And were you on shift on October 6th?
yes,
On that date, did you administer an intoxication test to the defendant?
yes,
And to the defendant, for the record, can you, is the defendant in this room?
yes,
For the record, can you point to the defendant and describe an article of clothing?
yes, a long sleeve button shirt, black and white.
Your Honor, just say with us that the record reflect that the witnesses identified the defendant.
Okay, well,
Prior to administering that test, was the defendant continuously in your presence for at least 15 minutes?
Yes,
Why do we do that?
to make sure the BAC, in this case, breath alcohol concentration level is as accurate as possible.
How does that ensure that it's accurate?
By me being in the same area, at least 15 minutes, and to observe that they didn't put anything in their mouth, or having gum, or vomit.
Did anything like that occur within that 15-minute period?
No,
Did you check to see if the defendant had anything in their mouth?
yes,
Did it?
no.
What intoxilizer model did you use to conduct these tests?
The 9,000,
And do you recall the serial number of the machine that you used?
yes,
What is that serial number?
90001482.
And can you please explain to the jury how an intoxilizer test?
I'm in the same area with whoever's providing the breast sample to make sure they don't vomit or throw up, because you want to be as equal as possible. Nothing like that occurs. You turn on the instrument, do a cycle, put the subject's name, date of birth, and verify that you've been watching for 15 minutes, your signature, and then go through the process.
And can you go into that process?
Yes. The instrument itself, it goes through operation check, then an airplane, and then calibration verification check, and then solution temperature, then the airplane. Then the subject will do the first test, airplane again, airplane, second test, airplane, calibration verification check, solution check, airplane, and operation.
Can you explain when you're saying airplane? What does that mean?
In the last results, it's the solution is trying to make the first results to be triple zeros. So when you get the second results, there's no BAC, in this case, alcohol concentration in the last results.
And is that essentially to ensure that the intoxilizer is performing?
Yes,
Were those tests done in this case?
yes,
There may I approach?
yes.
I'm showing you what's marked as State's Exhibit 4. Do you recognize this?
Yes,
What is that?
it's the results of the test.
And you see the results. What does this exhibit indicate that everything was done properly?
Yes,
How do you know that?
it would not be a valid test if anything occurs with the instrument. It would give you a incomplete test and give you a reason why it's incomplete.
And whose signature is at the bottom of that page?
That's mine.
And what were the results of this test?
That's a question a technical supervisor with the state of Texas would have to answer.
And what I've showed you with State's Exhibit 4 previously, was this the exact test that was used on that day for this defendant?
Yes,
And as we've gone over this a little bit, but as part of the automatic operation of the intoxilizer, does the instrument perform an operating system check before each test?
yes,
And are the results of that certain exam entered on the analytical report?
yes.
And what were the results of that?
I object, Your Honor.
Sustained.
And what's marked as State's Exhibit 4, what I just showed you, is that an original or a duplicate?
sorry, can you repeat?
What I previously showed you has been marked as State's Exhibit 4. Is that an original or a duplicate?
The original copy, I'm actually sure it's the original form itself.
State pass the witness, Your Honor.
Can I proceed, Your Honor?
Please.
And Mr. Varner. You indicated that part of your process is to make sure that the defendant is in your view for at least 15 minutes before administering the test. Is that correct?
Yes,
And it has to be 15 minutes, right?
yes,
And what is the reasoning behind that?
to make sure that the AC level is accurate at that time.
And that you're supposed to do that on every single breath test, correct?
Yes,
You didn't do that on this case, correct?
no, I'm sorry, repeat the question again.
I said you didn't do the 15-minute observation period on this case, correct?
No, that's not correct.
So you did do 15 minutes.
Yes,
And you're absolutely positive about that.
yes,
Just as positive as you are about the breath test and that the toxicology are working accurately, correct?
yes,
No doubt in your mind whatsoever.
no doubt.
May I approach your honor? And we'll probably need a break, Judge. I've got some videos I need to show him.
Okay, can you take the jury out, please? Jurors, we'll take a 5-minute break. I'll bring you back in and we'll continue. Okay.
All right, for the jury.
Please proceed. Ray, what you got? Have you seen this place? Do you know?
That's not.
No, it's not evidence, but it's an case.
Okay, got
Sorry.
it. Family, you ready? Ready?
I think the state wanted to address an issue with you regarding
Okay.
the videos, Judge.
Come talk to me.
I'll try.
What's the word?
So,
Yeah, yes. You want to just informally? Yeah, we could do informal first and then.
Okay, sure. So we're not on the record now?
Not right now.
Okay, talk to me.
So what I was showing him is the video from the intox room in JPC, where it shows that he comes in and then 6 minutes later is when he actually does the test. What they're informing me is that the observation period began outside, but there's videos from the outside, which we don't have, so there's no way of us to confirm the 15-minute observation period. I'm asking for these to come in just so I can make that argument. I think the state's going to object to it as to the weight of the evidence. That's wait. So I'm just.
You're objecting to him admitting this evidence?
I thought you said.
No, we're, no objection to the videos coming in. No,
Oh,
if you want to do that, that's fine. I'll just, I'll go back. and
Yeah, I'm gonna let it in regardless. I was gonna let it in.
I thought you said something about the weight of the evidence.
No.
I was saying if you are objecting to like something with a breath test, saying, well, the breath test isn't good because we don't have this video, I would just say it's not an
Is there a
admissibility
time
question,
that
it's a weight.
delineates when he was actually arrived at the station?
No,
Come on, there has to be.
it's not.
There always is. They document damn near
The
everything.
offense report, man.
The offense report does, but he can't testify as to the offense report.
No.
God, that's. Sarah, do you need anything before we start up? No? Okay. So let's go. You ready?
The food is here.
No, I want to see how far we can get, you know. Do you have any witnesses?
I don't have.
Yeah, just literally, just have them eat, deliberate and eat. You ready?
What's the food?
Pizza. I'm sure that they would run a get it and.
All right, for the jury.
Okay, please be seated. Ray, you may continue,
May I approach, Your Honor?
please.
And I'm sorry, do you have an official like title or designation or? Is Mr. Klein?
Yes.
Okay, Mr. Varner. During the break, I showed you some videos, correct?
Yes.
And those videos were contained on this USB drive, correct?
Yes.
Okay, and as far as you know, the videos that you observed are a fair and accurate depiction of what happened at that time, is that correct?
Yes.
And to your knowledge, have they been altered or modified in any way?
No.
Generating to opposing counsel for objections?
So this would be defense one,
That's one, yes, Your Honor.
No objection, Mr. St. John.
okay? It'll be admitted, and that is a USB of the intox room?
Yeah, that's correct, Your Honor. Two separate views from the intox room. May I publish, Your Honor?
Please.
All right, Mr. Varner, so this is the intoxilizer room at JPC, is that correct?
Yes.
And this is where suspects are taken in for their breath test, correct?
Yes.
Okay, so who do we see here in this video?
We Officer Metter and Reno. Gomez.
Close enough. Okay, so my client, you and Officer Metter, correct?
Yes.
Okay, and we're about the 1 minute 14 second mark, correct? Can I hear?
Yes, sir.
Okay. Well, I'm just going to fast forward a little bit because there's a lot of sitting around, is that right?
Yes, sir.
Okay, is this when you begin the breath test?
Yes.
Okay, and we're at the 6 minute and 45 second mark, is that correct?
Yes.
Is that 15 minutes?
1:45 to 6:45, no.
And so this is where you begin the breath test, correct?
Yes.
Now, you indicated on direct examination that you also check their mouths before they blow, is that correct?
Yes.
We don't see you check his mouth there, do we?
No.
Okay, and then this is just him blowing into the device, correct?
The first sample, yes.
Okay, and then there's a waiting period and then the second sample, correct?
Yes.
And as part of State's Exhibit State Exhibit 4. May I approach, John?
Please.
Is this your writing on the second page here?
Yes.
Okay. And without going into too much detail, what does it say next to breath?
MOAB.
And what does MOAB stand for?
Moderate odor alcohol beverage.
Moderate odor of alcoholic beverage?
Yes.
And is that something that you observed, or is that what you were told by the officer?
That's what I served.
Okay. So not a strong odor of alcohol, correct?
No.
And in your experience, how many times have you administered a breath test?
Almost 3,000 a year.
3,000 a year? Okay, so in all of those times, if they had a strong odor of alcoholic beverage, you would indicate that, correct?
Yes.
They had a moderate odor of alcoholic beverage, you would indicate that, correct?
Yes.
They had a mild odor of alcoholic beverage, you would indicate that as well, correct?
That would be moderate, it would be mild, or distinct.
Okay, so a difference between strong and moderate / mild, correct?
Yes.
And would you agree with me that just even a couple of beers could provide a moderate odor of alcohol, correct?
Yes.
I'll pass it to you.
Okay. Anything further?
Briefly, Judge. Was what we saw in the video the entire observation period?
No.
Why not?
So the DPC, we have limited space And we have, already talked about the first 8 people. And we don't have enough time to wait on rooms, so we have to reserve outside for both to go to the room. Or somebody else to use the room.
Did you do that on this test?
Yes,
And was the full 15-minute period observed?
yes,
And did you check his mouth before?
yes,
Was everything you did on this specific test done in accordance with your standard procedure?
yes.
Nothing further than to say that.
Okay? Great,
Very briefly, Your Honor.
okay?
And Mr. Varner, just so we're clear, there are, this was done at the JPC, correct?
Yes,
And that stands for Joint Processing Center, correct?
yes,
And there are cameras all throughout JPC, correct?
yes,
But you or whoever's in charge of your videos do not provide either the state or myself the video of the observation period outside, correct?
you're correct.
So the only thing that we can physically see is the 6-minute time period between the time you enter the room and the time you do the test, correct?
Yes,
Nothing further, Judge.
Okay. All right, may this witness be excused?
Nothing further than to say that.
No recall, right?
No recall.
Okay. Mr. Honor, you're excused. Thank you for your testimony. Be safe. You have one final witness?
Yes, Your Honor.
Okay. You want to keep going, last witness, or do you want to? All right, state, call your last witness.
They call Stephen Cooper to stand, Your Honor.
Okay,
Your Honor, this witness has not been sworn in.
okay. All right, Mr. Cooper, if you come on up, good afternoon.
Good afternoon.
Come up, please raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Any testimony you give will be the truth.
Yes.
Please speak loudly, clearly. If you hear the word objection, stop until we've addressed it, and then you may continue. Okay? All right. State.
Thank you, Judge. Can you please state your full name for the record?
Stephen Cooper.
And what do you do for work?
I am a forensic scientist as well as a technical supervisor.
And how long have you done
For about 7.5 years now.
that? Can you tell the jury a little bit about your educational background?
So I have a Bachelor of Science degree in biology from the University of Texas at Arlington, as well as a minor in biochemistry.
And do you hold any memberships in scientific or professional organizations?
Yes, I am a member of the International Association for Chemical Testing as the website chair. I'm also the past president of the Alcohol Testing Alliance.
And what are your current duties and responsibilities as a technical supervisor?
So they include being a custodian of records of all breath test records generated through the Texas Department of Public Safety for the area that I cover. I also train operators on the use of the Intoxilizer 9000. I testify in court for DWI trials, and I'm also in charge of the Intoxilizer 9000s in my area, performing any maintenance and inspection as needed.
And what is the Texas Breath Alcohol Testing Program?
So that is the program that oversees all Intoxilizer 9000s in the state of Texas, as well as operators being trained on the use of them for all breath DWI investigations being conducted.
And are you presently certified by the Texas Department of Public Safety as a technical supervisor?
Yes, I am.
What date were you certified on?
It was in December of 2017.
And what training do you have to have for that certification?
So it includes a several month-long training process, usually around 6 to 8 months. It includes attending various training courses taught by other technical supervisors in the area throughout the state of Texas. You also must attend various training courses outside of Texas, one of which being the Voir class hosted through Indiana University, where you learn about the physical and mental impacts of alcohol in the body.
You also must attend a course hosted by CMI, the creators of the Intoxilizer 9000, where they teach you how to perform maintenance of the Intoxilizer 9000. You then also must go through operator school, go through a mock trial process, and then have a written and oral test conducted.
Have you conducted any experiments on your own as to the workings and the reliability of the Intoxilizer 9000?
Yes, I have.
Are you familiar with the underlying scientific theory that the Intoxilizer 9000 instrument is based upon?
Yes, it's based upon infrared spectroscopy.
Can you explain that? What's infrared spectroscopy?
So essentially, in our instrumentation, you have an infrared light source and a photodetector analyzing that infrared light source. You can sort of envision this by, say, you're standing in a hallway holding a flashlight that's emitting light, and you have a friend at the other end of the hallway staring at the light coming out of your flashlight. Now, if you can sort of envision the hallway filled with something such as smoke, the more smoke that enters the hallway, the less light your friend is going to see. So similarly, in the instrumentation, the more ethanol on an individual's breath that fills the test chamber is going to absorb this infrared light, the less light the photodetector is going to see. And now the instrument is calibrated that as the light it sees increases, the concentration of ethanol in the chamber goes up. So it has a proportional calculation that it does at that point.
And is that theory considered valid by the scientific community?
Yes, it is.
Can you explain a little bit more about how the instrument specifically applies that theory?
So it's kind of applying it through what's referred to the Lambert-Beer law, stating that a constant temperature pressure proportion is absorption is proportionate to concentration.
And was that technique properly applied in this case?
Yes, it was.
How do you know that?
It's the scientific basis behind the Intoxilizer 9000. The instrumentation related to this have been around for decades now, and there's much research behind this.
Do you know an Intoxilizer operator by the name of Donald Varner?
Yes, I do.
Is Mr. Varner certified by the Texas Department of Public Safety as an Intoxilizer operator?
Yes.
And are you familiar with the Intoxilizer 9000 that was used in this case?
Yes, I am.
How are you familiar with that instrument?
It's an instrument in my area that I'm regularly responsible for.
And has the Intoxilizer instrument model 9000 been approved and or certified by the Texas Department of Public Safety?
Yes, it has.
Was this particular instrument certified and operated as part of the breath alcohol testing?
Yes, it was.
And as part of your duties, you stated you're responsible for the maintenance and monitoring of the instruments in your area. Can you describe to the jury what this involves?
So one of the first things that it involves is conducting our monthly quality assurance inspections. We travel to each of our locations throughout the Houston, Galveston, and Brazoria County area that are hosted in various courthouses and police departments. The first thing that I do upon getting there is ensure that the instrument is functioning properly. We also have a simulator device attached to the side of the instrument. It contains a known concentration of 0.08 in it, and we replace that on a monthly basis, and then we run a practice test. I also blow into the instrument to ensure that it's reading a 0 for myself. If any maintenance is required of the instrument, I would take care of it, most likely by removing it, replacing it in my lab, or performing some maintenance on the side if need be.
And what was the closest date before October 6, 2024 that you checked this particular Intoxilizer instrument?
That would have been September 23rd, 2024.
What was the condition of this particular instrument at that time?
It was functioning properly at that time after the technical supervisor initially forgot to plug in the simulator cable. She then plugged it in and had a complete test afterwards.
And what was the closest date after October 6, 2024, that you checked this particular instrument?
That would have been October 22nd, 2024.
And was the operational condition of this particular instrument, well, I'm sorry, excuse me. What was the operational condition of this particular instrument at the time?
It was functioning properly at that time as well.
And did that particular instrument require any repairs between the dates that you checked?
No, it did not.
And do you have an opinion based upon your experience and training as to the operational condition of that instrument on October 6, 2024?
Yes, that it was functioning properly at that time.
Governor, may I approach?
Yes.
Showing you what's been marked as State's Exhibit number 4. Can you tell me what this is?
This is a Texas forensic breath alcohol analytical report.
And as part of a particular test, is the operator required to have the subject continuously in his or her presence for a minimum period of time prior to conducting the test?
Yes, 15 minutes.
And what is the purpose of that 15 minutes?
It's to ensure that there's no residual amount of alcohol on an individual's breath that could falsely lead to higher elevations than what they actually are at.
Does the analytical report indicate the proper operational methods and testing techniques were followed in administering this particular test?
Yes.
How can you tell that from observing the analytical report?
I can tell that by observing that first and foremost, everything's printed clearly on the page. All of the air blanks are reading 0. The operator's signature is on the page, as well as an indication that they conducted the 15-minute waiting period. There's a test complete indicated on the page as well as no incomplete test messages either.
What is the calibrated verification solution?
So that
Yeah, I'm sorry, what was that?
What is the calibrated verification solution?
So that would be the simulator that I alluded to earlier. It is the reference device containing our known concentration. The instrument reads this twice during every subject test.
Who prepares the calibrated verification solutions for use with intoxilizer instruments?
That would be myself and my coworkers.
How do you prepare these solutions?
We typically will travel to Austin and create them in a large batch. We have a large container containing several hundred gallons of water that we fill up. We add ethanol to create roughly 500 bottles of 500 milliliters. And it contains our known concentration of 0.08. And then we label them, seal them, and then we use them on a monthly basis.
And how, I'm sorry, are those solutions periodically checked?
Yes, monthly.
And how is that done?
That is done at our monthly inspections. We use a new bottle every single time, and then we conduct a practice test with it.
How is the predicted value entered into the Intoxilizer 9000?
So there is no predicted value entered into the Intoxilizer. The instruments are calibrated in our lab, and then the calibration is verified using these simulators with the reference device, with the reference samples in them, sorry. And that's done just to verify the instrument is calibrated properly. And then when an individual blows into the instrument, it uses its calibration to essentially analyze the individual's breath at that point.
Does the analytical report that's marked as State's Exhibit 4 reflect that the result of the calibrated verification system was within the tolerance level of the analytical report value?
Yes, it does.
And what happens if it's out of tolerance?
So if the instrument, reads its calibration verification, outside of the, acceptable range of 0.07 to 0.09, then the instrument will flag an incomplete test with an exception message stating cal verification out of, tolerance.
And what happens if it is out of tolerance? Or I'm sorry, excuse me. No. What does alcohol concentration mean?
In regards to what?
The analytical report says alcohol concentration. What does that mean?
Are you referring to the subject results?
Yes.
So that would be the 2 breath samples that, each subject, administers throughout the breath test. They provide the first one, and then they provide the second one, approximately 2 minutes later.
What steps should the operator of the intoxicator follow if taking a breath sample?
So the first thing that must be conducted is the 15-minute waiting period. Then at that time, the operator will then input the subject's information into the instrument through either scanning, typing, or swiping their driver's license. They then confirm that they conducted the 15-minute waiting period along with their signature, and then they can start the test at that point.
And then can you please describe for the jury the steps the instrument automatically?
Sure. So the first thing that occurs during this sequence of analysis is the operational system check. It's when the instrument performs an electronic check on itself to confirm that everything's functioning properly. There's then a 30-second air blank conducted. This is the instrument purging the testing chamber to ensure that there are no foreign contaminants or residual alcohol left behind. The instrument then goes through its first calibration verification check where it checks that known solution that we have attached to it. The instrument will then go through a second air blank to again purge the sample chamber. At that point, the subject then provides their first breath test sample. There is then a third air blank followed by a 1-minute waiting period. And then at that point, it's just a mirror image from what I just went through, ending on the second final operational system checks.
And what were the results of the 2 breath samples of the subject in this case?
I'm gonna object, Your Honor, that has not been entered into evidence yet.
What was your question?
What were the results of the 2 breath samples of the subject in this case?
Okay, good.
And just again, you verified that this is the analytical report that was used for this test, right?
Yes.
And it's a true and accurate depiction of that analytical report.
Yes.
I'm tendering State's Exhibit 4 for defense inspection.
Improper predicate, Judge.
I'm showing you again what's been marked as State's Exhibit 4. Did you review this analytical report?
Yes.
Does the information here match everything in this case?
Yes.
And this is a fair and accurate copy of that report.
Yes.
Your Honor, I'm tendering State's Exhibit 4 to defense counsel for inspection.
Still believe it's improper predicate, Judge.
Say it again?
I believe it's still improper predicate.
One more. Go ahead.
I can't hear you. Just put on.
Mhm. Well, the only thing I don't think that is it has been altered in any way, you know? That's fine. That's fine, Judge. There's still one missing. Huh? There's the one missing. I don't know. I can't think of what you're asked to say, but if you have an objection. Okay, I mean, just. May I tell the court ex parte? I don't want. If I say it. Yeah, I mean, I just. She lost her question. Okay. Yeah, that's that. I don't have a problem. But go, but it's.
Gentlemen, may I approach?
Please.
All right. I'm showing you again what's been marked as safe and good full. Are you the custodian of records for these types of records?
Yes,
For this particular one?
yes,
Is this the type of record that's kept in the normal course of business for the Department of Public Safety?
yes,
Has it been altered in any way?
no,
Your Honor, the state is tendering to defense counsel for inspection.
Objection?
No objections, Your Honor.
All right, it'll be a minute.
Judge, you indicated.
Yes. It'll be 4.
Yes, Your Honor.
Okay.
Your Honor, may I publish for the jury?
Please.
And we've already gone over this, but just to refresh, this is the exact document used that is reflective of the results from the specific breath test for this defendant.
yes.
And what were the results of that test?
They were 0.153 and 0.160 grams per 210 meter.
And are these results greater than or less than the legal limit of intoxication set by the state of Texas of 0.08 grams to 210 liters of breath?
They are greater than.
Good, thank you. With the results of these 2 breath samples within the allowed tolerance specified by the scientific director of the Texas Department of Public Safety?
Yes, they were.
And again, what happens if the 2 breath samples are not within the allowed tolerance?
So if the 2 breath samples are not within the allowed tolerance of 0.02, then the instrument will flag an incomplete test with an exception message stating no subject 0.02 agreement.
During the course of your training, did you learn about the effects of alcohol upon a person's mental and physical faculties?
Yes, I did.
Based on your training and experience, how can alcohol affect a person's mental faculties?
So mentally, one of the first things impacted is an individual's judgment. Next, things affected would be in individuals' inhibitions. They might start doing things they wouldn't normally do. The perception, they might start seeing things happening around them that might not necessarily be exactly how they're occurring. Then an individual's vision can be impacted. This can result in blurry or double vision, and especially in individuals' tracking ability, so the ability to follow objects from side to side, either while they're driving or walking.
And based on your training experience, have you or yourself conducted or participated in any experiments on the effects of alcohol on a person's mental and physical faculties?
Yes, I have.
And based upon your studies and your own experience, do you have a personal opinion as to the alcohol concentration at which a person does not have the normal use of his or her mental or physical faculties?
Yes, and I would say that that would be 0.08, with some individuals displaying signs of intoxication at lower concentrations as well.
Why do you hold that?
I hold that opinion based off of research as well as dosing operators at operator school, as well as myself being dosed at operator school, and just from personal experience as well.
And in your opinion, would a person with an alcohol concentration of 0.153 or 0.160 have lost the normal use of his or her mental or physical faculties?
Hold on. I'm gonna object, Your Honor. I don't believe this witness has been established as an expert, so I hope not provide an opinion.
Really? Response?
Your Honor, based on the witness's educational background that he provided, his training and experience which he provided, the extensive training that he provided, it.
Yeah, I'm gonna overrule the objection. Sorry. Okay.
In your opinion, would a person with an alcohol concentration of 0.153 or 0.160 have lost the normal use of his or her mental or physical faculties?
Yes.
And why do you hold that opinion?
I hold that opinion based off of my training, personal experience, and as well as research as well.
And there's two subject results. Why are there two numbers?
That is because each individual that has the test administered on them, they provide 2 breath samples. And usually in terms of calculations, we typically will go with the lowest of the 2 to give the benefit of the doubt to the subject.
Are the subject's test results a representation of his or her alcohol concentration at the time of the test or at the time of driving?
At the time of the test.
Is it possible to determine a person's alcohol concentration at the time of driving?
Yes, it could be, as long as specific facts are provided, and that would be referred to as a retrograde extrapolation.
Can you explain that process for the jury?
Sure. So it entails with specific facts such as the time of last drink, time of last meal, time of stop, as well as a concentration that an individual blew at a time of test. It is possible to determine what an individual's alcohol concentration would have been at a previous point in time, such as the time of stop or time of incident or time of driving, all kind of referring to the same thing now.
And what is absorption?
Absorption is the process of ingesting alcohol, usually through the form of drinking it, and then it being absorbed into the body largely through the small intestine.
And what is elimination?
Elimination is the body's process of eliminating alcohol from the body. Alcohol is metabolized and broken down by the liver, but it is also eliminated through breath, sweat, and urine, with the breath elimination being the basis for which a breath sample is provided and analyzed through the intoxilizer.
Given the facts in this case, were you able to extrapolate?
I would need to know those facts before being able to.
State passes the witness, Your Honor.
Okay. There you are.
Yeah.
All right, Mr. Cooper, is it Dr. Cooper?
Just Mr. Cooper. Okay.
I don't want to be disrespectful or anything.
Oh, no, you're fine.
Okay, so your state just finished up their questioning with extrapolation, is that correct?
Yes.
Okay, so you would need a specific set of facts to make that determination, correct?
Correct.
And if you don't have the specific set of facts, you cannot extrapolate back, is that correct?
That is correct.
So again, it's 0.153, 0.160, that's at the time he blew, but not necessarily at the time he was driving, correct?
Correct.
Now, you talked about the 15-minute waiting period. What was the Or what's the importance of that 50-minute waiting period?
It's to ensure that there's no residual amount of alcohol in an individual's breath that could be leading to a false elevation or test reading, such as if you were to take a shot of liquor and then immediately blow into the instrument, the excess alcohol in your mouth would read exceedingly higher than what your actual blood concentrations.
Okay, and if the 15-minute period is not observed, would that be a problem?
If it was not properly observed, it would be a breach in our procedures.
And in your training and experience, you indicated that somebody with 0.153 could have lost their judgment, and inhibitions, things like that, correct?
Correct.
Also in your training and experience, is it possible for somebody to be below 0.153 and not have lost all of their faculties?
As far as what concentration?
We don't know, but let's say if they're below, because you talk about the body absorbing, right?
Correct.
So your body has to absorb alcohol first, correct, before it can eliminate?
Yes.
And that's a process that takes some time, correct?
Elimination begins at the same moment that absorption would begin.
Okay, but that doesn't happen like immediately, like you don't take a shot and it immediately starts absorbing and eliminating, correct?
A small amount is absorbed in the mouth and the stomach lining, with the majority being in the small intestine.
Okay, but in the mouth and stomach lining, that would not register on this machine, correct?
It depends on how much is absorbed. I would assume that it would not lead to a very high reading at all.
Okay. So again, if somebody was below this amount, would they lose their mental and physical faculties? Or would it depend on their tolerance?
I would say that all mental faculties are for sure lost at a 0.08. Tolerance that an individual has displayed could affect the outward signs of their physical faculties being impaired.
Okay, so you're saying all mental faculties would be lost?
At a 0.08, yes.
Okay, so a mental faculty would be the ability to drive a vehicle, correct?
Yes, I would say that that is utilized in that.
Okay, so if somebody's still able to drive a vehicle, based on what you just said, that means they would be below a 0.08, correct?
I would say the ability to drive is largely impacted by how well they're driving, impaired versus not impaired.
Okay. So you would expect to see swerving?
Potentially.
You would expect to see maybe an accident?
That could be a possibility, yes.
Okay. You would expect to see possibly erratic driving, kind of all over the road, maybe hitting another car or coming close to hitting another car, things like that?
That could be a possibility as well, yes.
Okay. What about speeding?
Yes, I would say that could be an indication as well.
Okay, but have you ever received a speeding ticket?
Yes, I have.
And were you intoxicated when you received that speeding ticket?
No, I was not.
So it's possible to speed even though you have all of your mental faculties, correct?
That is correct.
So speeding is not by itself indicative of intoxicated driving, correct?
No, it could be still a sign of intoxication.
Would you expect to see others?
Potentially.
Now, are you familiar with the standard field sobriety tests?
I am roughly familiar with them, yes.
So you're not certified in them, correct?
No, I am not.
Now, this machine you said was last tested on 9/23/24, correct?
Before the subject test, yes.
And you said that the operator at that point forgot to plug in a tank, is that correct?
Nikithia Rogers, she forgot to plug in the simulator communication cable, which is what connects the simulator to the toxilizer.
Was that the case when this breath test was taken?
No, that was during her QA inspection.
All right, so just to be clear, these results are at the time of the breath test, correct?
Correct.
And without additional facts, you cannot determine what his alcohol level was at the time of driving, correct?
Correct.
Nothing further, question. Okay.
Anything further, State?
Judge, maybe, Coach.
Sure. Scoot on. I know. Yeah, that's what he said. No, he has done. Well, he testified that there was one that was like there was different testimony as to right. So yeah, I mean, what are you trying to do? How? Not through him.
No, not to him. It would have to be prior. But
You can't use him.
no, I can.
Right. Okay, let's continue. Okay, thank you. So, State, do you have anything further?
Yes, Your Honor.
Okay. Make it brief.
Outside the 0.08 number, are there other factors to be considered when determining if an individual is intoxicated?
In regards to mental and physical faculties,
Yes.
some individuals could display signs of intoxication even after their first drink of alcohol. Tolerance also plays a factor as well. But tolerance is only the outward display of being able to mask your physical signs of intoxication, and it has no impact on your mental signs of intoxication.
So it isn't just one specific thing that tells you whether an individual is intoxicated or not.
I'm not really sure what you're asking.
Do you evaluate multiple factors when making your analysis?
I'm gonna object, Judge. I don't know exactly what he's asking. If there's multiple factors as to this breath test,
He's right.
Yes, Your Honor. I'll rephrase.
Okay.
I'll move on.
Okay.
Was everything for this breath test done in accordance with standard policy? Procedures?
As far as what I've observed on the breath records, yes.
Nothing further than stated.
Okay.
no, Your Honor.
All right. You may step down.
Thank you.
State, do you have any further witnesses?
No, Your Honor.
Okay, so you rest.
Yes, Your Honor.
Okay.
I'll have a motion, Judge.
Okay, so hold on. Can you take the jury out for 1 second? But don't take them far. Yeah, but just don't take them far.
All right, for the jury.
Okay, please be seated.
You found right out that door, there's gonna be a ghost.
Sure, of course. For what it's worth, I don't think they can hear anything, but absolutely.
just
Yeah.
rather
Of
safe
course.
start.
Absolutely.
So Judge, I'd be asking for a motion to directed verdict. I believe the state has failed to meet its burden beyond a reasonable doubt. First and foremost, they never established whether or not he was operating a motor vehicle. They identified the type of vehicle, but they didn't ask any witnesses if it was a motor vehicle. And that was never established. That's the first part. Second part, I don't believe they've established intoxication beyond a reasonable doubt. They never asked any of their witnesses if the person had lost the mental or physical faculties. All they did was go through the field sobriety tests and then indicate what the results of the field sobriety tests were. But none of the witnesses indicated whether or not they had lost their mental or physical faculties. And on top of that, finally, Judge, with this witness, the breath test, he was able to establish that the breath test was done at the time of, or that was his blood alcohol concentration at the time of the test, not at the time of driving. Without any additional information, there's no indication what his blood alcohol was at the time of driving. So therefore, I don't believe they've established their burden as one, as to a motor vehicle. Two, which the complaint or the information says operated a motor vehicle in a public place in Harris County, Texas. And then also as far as the intoxicated portion, like I said, no testimony as to loss of mental or physical faculties, and no indication that it was at a 0.08 or higher at the time he was driving. So I'd ask for a directed verdict at this time as the state has failed to meet its burden.
Your Honor, I'll try and go in order here. The facts clearly show that it was a motor vehicle, maybe simply because I didn't ask for a conclusory statement from the witness, but demonstrated that the defendant was in fact driving a motor vehicle by the facts that were given. The officer testified that the defendant was the driver of the vehicle. There was no one else in the vehicle. That he witnessed the vehicle the entire time from when he first went to.
Yeah, stop. I disagree. I think that there's enough to go forward. I do. I think they testified to it that, we asked them the ultimate question. So, I mean, I think that there's enough to go forward.
But my understanding, Judge, is that the state has to meet each and every one of their elements beyond a reasonable doubt. One of the elements is a motor vehicle, and that was not established beyond a reasonable doubt at all.
He testified that he pulled him over.
Correct, Judge, but it could have been a go-kart, it could have been anything.
He's on video in a car.
Your Honor, the state still has
Okay,
to
no.
establish.
I disagree. I think that they've met it. Let's go from.
All right, for the jury.
Now, and then we'll do the charges. I'm gonna like invest in you. All right, everybody, please be seated. Okay, so you have rested. Defense, do you have any witnesses?
We do not have any witnesses, Your Honor.
Okay, so defense rests. Okay, so now we have some business matters to attend to prior to closing. So what I'm gonna do is I'm gonna feed you guys now. I know that you're probably pretty hungry, so I have lunch for you now. We're gonna try to, like I said, be as efficient as possible. So eat. I'm gonna bring you back probably 15 minutes, so we can just get started and keep moving, okay? We're close though, all right? Please.
All right, for the jury. All right, for the jury.
All right, please be seated. Okay, filet and lobster good? Okay, members of the jury. The defendant, Odir Alberto Gomez Santa Maria, stands charged by information with the offense of driving while intoxicated in Harris County on or about October 6, 2024. To this charge, the defendant has pleaded not guilty. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take with you and to use during your deliberations. Both sides will soon present final arguments. Before they do, I now give you the instructions you must follow in deciding whether the defendant has been proven guilty or not. You will receive a written copy of these instructions to take and use during your deliberations. First, I will give you some general principles of law that you must follow when deciding this case. Then I will instruct you on rules that control your deliberations. Finally, I will tell you about the specific law that applies to this case. The information. The information is not evidence of guilt. It is the name of a document required to bring the case before you. The information cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or otherwise charged. You may not draw inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proven beyond a reasonable doubt. The law does not require a defendant to prove his or her innocence or to produce any evidence at all. Unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case, the presumption of innocence alone is sufficient to acquit the defendant. The burden of proof throughout the trial is always on the state. The defendant does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt of the for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. If it is not required that the state proves the defendant's guilt beyond all possible doubt, it is required that the state's proof exclude any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If after you've considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not in evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not in evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of testimony of the witnesses and materials admitted into evidence. Nothing I have said or done in this case should be considered by you as an opinion about the facts of this case or influence you to vote one way or the other. You should give terms their common meanings. Ready? Do you mean to go back?
Me.
Okay. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meaning provided in these instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits that are justified in light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. You must follow these rules to request that testimony be read back to you. The court will allow testimony to be read back to the jury only if the jury, in a writing signed by the foreperson, 1, states that it is requesting the testimony be read back, 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute, and 3, identifies the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in disagreement. The verdict. The law requires you to render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant's guilt beyond a reasonable doubt. You may return a verdict only if all 6 of you agree on a verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. Oh.
We go about 30 seconds back, Judge.
Sure.
Sorry.
You want to go back from the verdict?
When you turn a verdict, only if all 6 of you agree.
Okay, so you may return, Tony, ready?
Yes.
Yeah, okay. You may return a verdict only if all 6 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him and is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had testified or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. These are the rules that control your deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go into the jury room. Your first task will be to pick a foreperson. The foreperson will preside over your deliberations and conduct them in an orderly way. Each juror has 1 vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss this case with any court officer or the attorneys or anyone not on the jury. 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves, then you must stop your discussions about the case until all of you are present again. You must communicate with me only in writing signed by the foreperson and given to me through the officer that is assigned to you. You must not conduct any independent investigations, research, or experiments. Number 5, you must tell me if anyone attempts to contact you about the case before you reach a verdict. Your sole duty at this point is to determine whether the defendant has been proven guilty. You must restrict your deliberations to this matter. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict. Disregarding evidence if unlawfully obtained. You have heard evidence obtained as a result of a traffic stop and detention of Alberto Gomez Santamaria by Officer Micah Metter. Specifically, you have heard the testimony of Officer Micah Metter and other state's witnesses, as well as evidence of a breath test suggesting that Alberto Gomez Santamaria might have been operating a vehicle while intoxicated. You may consider this evidence only if you resolve a preliminary question in favor of the state. No evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America shall be used against the accused on the trial of any criminal case. The state must therefore prove beyond a reasonable doubt that the evidence was not obtained in violation of the law. A police officer may, under the law, stop and detain a motorist without a warrant when the officer has reasonable suspicion that the motorist has committed a criminal offense, including a traffic offense. Before you may consider the evidence obtained as a result of Officer Micah Medder's stop and detention of Odier Alberto Gomez Santamaria, you must all agree that the state has proven beyond a reasonable doubt that Officer Micah Medder reasonably believed that Odier Alberto Gomez Santamaria was speeding and or had expired registration before Officer Micah Medder stopped him. If you find that beyond a reasonable doubt, then you may consider all of the evidence obtained as a result of Officer Micah Medder's stop and detention of the defendant. If you do not find that fact beyond a reasonable doubt, then you will disregard all evidence obtained as a result of Officer Micah Medder's stop and detention of the defendant, and you will find Odier Alberto Gomez Santamaria not guilty. The law on driving while intoxicated. You are instructed that a person commits the offense of Class B driving while intoxicated if the person is intoxicated while operating a motor vehicle in a public place. In this regard, public place means any place to which the public or substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospital, apartment houses, office buildings, transport facilities, and shops. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. Intoxicated means, number one, not having the normal use of mental faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body. Two, not having the normal use of physical faculties by the reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of those substances, or any other substance into the body. Or three, having an alcohol concentration of 0.08 or above or more. Alcohol concentration means the number of grams of alcohol per 210 liters of breath. You are further instructed that if it is shown during the trial that an analysis of the specimen of the person's breath showed an alcohol concentration level of 0.15 or more at the time of the analysis was performed, then the person has committed the offense of Class A, driving while intoxicated. Or you are instructed that if you believe beyond a reasonable doubt that Odier Alberto Gomez Santamaria breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, you will find the defendant guilty of the offense of DWI misdemeanor 0.15 or greater and say so by your verdict. But if you do not so believe, or if you have a reasonable doubt thereof, you will proceed to consider whether the defendant is guilty of the lesser offense of DWI misdemeanor Class B. Class A, driving while intoxicated. Now, therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, Odier Alberto Gomez Santamaria, on or about October 6, 2024 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, and you further believe from the evidence beyond a reasonable doubt that an analysis of Odier Alberto Gomez Santamaria's breath showed an alcohol concentration level of 0.15 or more at the time the analysis was performed, then you will stop your deliberations and find the defendant guilty of Class A driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, then you will consider whether the defendant has been proven guilty of Class B driving while intoxicated as instructed below. Now, therefore, if you believe from the evidence beyond a reasonable doubt that defendant Alberto Gomez Santamaria on or about October 6, 2024 in Harris County, Texas, did then and there unlawfully operate a motor vehicle in a public place while intoxicated, then you will find the defendant guilty of Class B driving while intoxicated. If you do not so believe, or if you have a reasonable doubt thereof, then you will find the defendant not guilty. I've now signed the verdict sheet. Each side will get 20 minutes for closing. State.
Thank you, Your Honor. The state waives its opening and reserves its time for closing evidence.
Okay. Defense, you may start.
May I proceed, Your Honor?
Please.
I told you at the beginning of this case, in my opening, of the things you would not hear. I told you would not hear what his exact speed was. And I told you would not hear what his blood alcohol content was at the time he was driving. Out of all 4 witnesses that the state has put on, not a single one of them could say that with absolute certainty. Nobody can tell you either one of those facts. You heard from the analyst who said that he would need specific facts to determine what his alcohol level was at the time. He talked about absorption, how alcohol enters the body, how it takes some time for the alcohol to enter the body. And when asked, can you do that in this case? I believe the state asked him that. He couldn't. So we don't know what his blood alcohol content was at the time he was driving. We know what they claim it was, or what the sheet shows it was at the time that he blew. That doesn't mean that's what it was when he was driving, right? Then he talked about the mental faculties and physical faculties. And the analyst told you that he believes somebody with a 0.08 loses all faculties. Right? And I asked him, does that include driving? He said, yes, I believe it includes driving. I said, would you expect to see other driving patterns? Would you expect to see swerving? Yes. Would you expect to see an accident? Yes. None of that happened here. It was supposedly speeding was the only issue, right? And let's talk about the speeding. Officer Metter found northbound on South Chester. He says he knows that intersection well because the station is not far from there. And he knows how fast somebody's going because of the flow of traffic that goes from there. There was not a single car on that road, not one. He admitted it. My client had the green light. He didn't run a red light. In fact, we see him stop at the appropriate place at the next intersection. So it doesn't run a red light. There's no traffic to compare his speed to. Metter waits 10 seconds before even pulling out, or 8 seconds before even pulling out to go after him. And then when he does go after him, he claims he hit 64. He says that you can see that on the video. We didn't see that on the video. There's nowhere on that video that doesn't show what his speed was. Why? Because we don't know what his speed was. That's just what he said it was. Right? The evidence speaks for itself, ladies and gentlemen. Evidence speaks for itself. So then he says it's about a quarter mile to the next stop. So if he's doing 65, and my client's doing 65, he even admitted to you, Metter admitted to you, that my client would have been long through that next light before Officer Metter even hit it at a quarter mile. He was not doing 65, ladies and gentlemen. In fact, we don't know how fast he was going. Why don't we know how fast he was going? Because Metter didn't try to put a radar on him. He didn't try to do anything except pull out and say, I'm going to go stop this guy. And then when he gets up there, here's where the state wants you to say, oh, this is the problem. This is a reasonable cause or a probable cause for the stop.
He runs his plate and finds out the registration was expired. Okay, I asked Mayor specifically, is expired registration indicative of intoxicated driving? Of course not, right? It's a fix-it ticket. That's what you get. You gotta get registration, pay the ticket, case gets dismissed. So, and I asked him, but for the fact that you perceive my client to be speeding, would you ever run his plate? He said no. Why? Because he was going the opposite direction. He was going northbound, client was going eastbound. Westbound. Had to do the never eat soggy Wheaties. Yeah. So client was going westbound. Complete opposite direction. So, but for Metter thinking that he was speeding, he would never pull up behind him. He never pulled up behind him. He would never run his plates. He never run his plates. He would never have seen the registration was expired, and therefore my client would never have been pulled over. Let's talk about the investigation itself. When he pulls into the gas station, Metter realizes Mr. Gomez doesn't speak English very well, so he calls for a Spanish-speaking officer. Ruiz shows up. Ruiz starts talking to him. And Ruiz told you that he didn't translate everything verbatim. He paraphrased it, is how he put it. Metter testified that there were inconsistencies in my client's statement, which led him to believe that he maybe didn't have the mental use of his faculties due to intoxication, right? But there were no inconsistencies. You heard Ruiz talk about coming out from Cleveland, helping the client move. Ruiz didn't translate that all. All he said was he came from Cleveland and he helped the friend, right? Then later on, he says again, he helped the friend move. And then Ruiz says that. And then Metter tells you, well, that's an inconsistent statement. He told you he came down to get gas. He was coming from his house to go get gas because gas is cheaper on the side of town, right? That's what the client said, right? And Ruiz said that. Officer Metter says, oh no, that's an inconsistent statement. He never said anything about getting gas before. He said he had come down, helped a friend move. He said that the first time, and he said it the second time. And then they asked him, well, where is he going? He said, he was coming down here to get gas because it's cheaper, right? So he came to get gas because it's cheaper in that thing. Then Metter goes on to talk about, oh, I pass all these gas stations. Well, we all know there's gas stations everywhere. Every single gas station has a different price. I know I've got my favorite one I always go to, and I will pass a dozen other stations to get to that one to get the cheapest price on gas, especially nowadays, and especially coming into the summer months. We all know that. So everything that Metter told you or used in the totality of circumstances is perfectly reasonable. Now let's talk about the field sobriety tests. They want you to start right here, like this, right? I'm struggling to do that, and I have perfectly good balance. You start here, and then you've got to do heel to toe for 9 steps, and then a series of small turns. I know the SFSTs inside and out. I was a prosecutor, I was a police officer, a prosecutor, and now a defense attorney. I've done these thousands of times. I've seen them thousands of times. All right, so I can do them. My client got 1 time on the instructions. Metter claims he took 8 steps instead of 9. Okay, maybe he miscounted. All right, and then a series of small turns. They expect somebody to do this to turn around. All right, that's not a natural movement. Everybody, when you turn around, when you're just thinking, I got to turn around and go back, you get to the end, you turn around, and you go back. No falling over, no stumbling, nothing. Just an unreasonable test that is perfectly unnatural for a human body to perform. And he claims that the National Highway Safety and Transportation Committee established these so that it would be difficult. Sure, maybe that's the case. But even a sober person, I believe he even said, somebody, what were his exact words? It was relatively easy for somebody who is not intoxicated. Not completely easy, not perfectly easy, not easy at all. Right? Relatively easy for somebody who's not intoxicated. So the field sobriety test, useless. Absolutely useless. And then he talked about, him and Ruiz both said, there's a strong odor of alcohol on his breath. Right? But then I asked, if you have one, maybe 2 beers and have a strong odor of alcohol on your breath. Yes. I asked Metter, if you have 2 beers, are you intoxicated? No. And then we get to Varner, and Varner says it was a moderate to mild odor of alcohol on his breath. Which one's the truth? We don't know. We weren't there. But that's completely unreliable as well, because there's inconsistent statements. If Metter wants to use the inconsistent statements, that's an inconsistent statement amongst the state. These are the people that work for the prosecutors. This is their job. Their job is to find people guilty, for the state, not the prosecution. Their job is to look for things to find people guilty. Right? That's what they try to do. So they're going to say what they want to say to get to that point. Now, as far as the jury instruction, there's a section in the jury instructions that says you are to disregard evidence if unlawfully obtained. Page, I believe it's 5. 1, 2, 3, 4, 5. Page 5. An entire section talks about evidence unlawfully obtained. I've already explained this to you, but I'm going to go over it again. Metter says he knows that intersection. Based on the flow of traffic, he believed my client was speeding. There wasn't traffic. He couldn't go after him. He couldn't tell how fast he was going. Then he goes out after him. A quarter mile later, he catches up to him and runs his plate. That is, without him thinking that my client was speeding, he would never run that plate. That's unlawfully obtained evidence. He just looked for something to find.
Objection, Your Honor. May we approach?
Why just was it? I said like for him going after me. Or so. Okay, at the end of it. Right, and so you can as well. All right, come on. Okay, 3 minutes.
So, again, speeding goes in behind one's plate. That tells you here down at the bottom, and/or expired registration, right? What I'm asking you to think of is, why did he find out that registration is expired? What led him to that? But for him perceiving a speeding, he would have never run that plate. And if you find that probable cause did not exist, or as well as you don't believe that he lost his mental faculties, we didn't see him fumbling, we didn't see him walk, urinating himself.
We didn't see everything during jury selection. I think somebody said that. They urinate themselves, right? They stumble, they act a fool, they're belligerent, things like that. We didn't see any of that. What we saw were those unnatural field sobriety tests that are designed for people to fail. That's what we saw. Nothing else. No other driving facts. So no loss of mental faculties, no loss of physical faculties. And then they say at the time that he flew, his alcohol was 0.153, but nobody can tell you what it was at the time he was driving. The law is driving while intoxicated, not intoxicated when you blow into the machine. Driving while intoxicated, which means they have to prove beyond a reasonable doubt that at the time he was driving, he either lost his mental faculties, lost his physical faculties, or was it 0.08 or higher. They have proven absolutely none of that. So ladies and gentlemen of the jury, you have one verdict and one verdict only. It's at the very top right there for you. We, the jury, find the defendant, Alberto Gomez Santa Maria, not guilty. Thank you very much for your time.
Okay, thank you. All right, state.
Thank you, Judge. Judge, may I publish a PowerPoint for the jury? May I publish a PowerPoint for the jury?
Sure.
All right. Defense said a lot of things. Some of it confusing. Some of it, right? Let's start with the jury instructions. This piece he pointed out to you said disregard evidence if unlawfully obtained. There's a piece I want to circle here. It does not say that you must all agree the state has proven beyond a reasonable doubt that Officer Vikky Metter reasonably believed that the defendant was speeding. It says was speeding and or had expired registration. Ladies and gentlemen, it isn't hard. The officer thought he was speeding. He goes to the light, the officer sees him, he follows him, he tracks him, he pays him. Was it perfect? No. But he gets up to the light and he runs his registration. He finds that his registration is expired. That's all he needs. That's it, right there. That's what the jury instruction says. It says or. If you find that he had expired registration, it doesn't matter. Look at all the evidence. Now, let's go through this and let's make it easy, like I told everyone. Every single person, except for the last witness, said that this occurred on October 6, 2024. That's an easy one. Let's cross that one off. The officers both said it was in Harris County, Texas, and in a public place. We know that it was this defendant. How do we know that? Because the officer said it was. Because the officer said, I was going down the road, I saw this car, I pulled him over, and he was the one behind the wheel, and you see him on the video. Let's cross off another one. Operated a motor vehicle. How do we know that? You saw it on the video. The officer told you everything you needed to know. It's not hard. In a public place. You see on the video, he's at a gas station. The officer tells you he's at a gas station. And he's operating the vehicle on a public roadway. Straight from the officer. It's not hard. None of those are hard. And fairly useful. Then we get to while intoxicated. This is still easy. Why is it easy? How do we know he was intoxicated? Because I have this piece of paper that says subject name, that has the operator that you heard from, his signature on it. And it says what his DNC was when he blew. Now, this is important. What does it say? Let's use the low one, 0.153. This is a smaller detail that you may not have caught, but you have to use your memory, think back. When the officer was telling you about the HGN, you remember there was a small part at the end of the HGN where he said, he was talking about the onset prior to 45. And it's what the officers used to calculate about where the defendant is on the scale. He told you what he thought the defendant was at that point in time was what? It was around 0.15. And then he went and got a breath test and he confirmed it. That's all it is. It doesn't have to be hard evidence. Remember yesterday we were talking during jury selection and I brought up Stonehenge and I said, and I told you, you might not have the full picture, but you don't need the full picture. When you get enough pieces together in a puzzle, you know what the picture is. And that's all this is here. We have all the pieces we need. Only thing left for you to do. So go back in the jury room, pick a format, and return a guilty verdict. That's what I'm asking you to do right now.
All right, thank you. All right, ladies and gentlemen of the jury, it's now time for you to deliberate. Get you going, do you mind escorting them to the jury room? Okay, all right, so, good luck. Okay, we're in recess. Question?
Yes.
Verdict.
I'm assuming it was one.
Think it's a question?
Yeah, one question.
Yeah, but they always hit just one. They never did two.
Oh.
Mm.
You got a question? Question?
Or we heard a ding. I don't know. Verdict. Hey, we have a verdict. Ramona. Let me go get Ramona.
All right, for the jury.
Okay. Ladies and gentlemen of the jury, have you reached a verdict? Is it unanimous? Okay. I'm now going to read to you in the state of Texas, cause number 2532700, the state of Texas versus Odir Alberto Gomez Santa Maria. We, the jury, find the defendant guilty of Class A driving while intoxicated as charged in the information. Okay, you've been found guilty. You may take a seat for a moment. Does anybody would like the jury polled?
Yes, Your Honor.
Okay. Ladies and gentlemen of the jury, is this your verdict, man? Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Your verdict?
Yes.
Your verdict. Okay.
Thank you.
All right, sir. Let me just give me a second. Ladies and gentlemen of the jury, you have concluded your service. I thank you for everything that you've done. It's really an invaluable service. You may now retire to the jury room. If you give me a couple minutes, I'll come back there and talk to you, and then we'll try to get you all the things that you may need to get you out of here. Yeah. Thank you.
All right, for the jury.
Please be seated. Mr. Gomez, I want you to understand that you do have the right to appeal this verdict. If you decide to do that, there are certain timing requirements that must be fulfilled and documents filed. I can let your attorney explain as much as he knows, if that's something that you want to do, but timing is of the essence if you want to appeal this, but you do have that right. We do have to sentence, and if I'm correct, parties you have agreed to a sentence.
Yes, Your Honor.
Okay, and the agreement is
210 days.
with credit for the 73 days. Okay, I'm now going to sentence you to 200 days in jail. I will give you credit for 73 days that you have done. Mr. Gomez, you need to understand that this will now reflect as a conviction on your record. This now makes 2. If you ever pick up another DWI, you will be charged with a felony offense, and you will be looking at a minimum of 2 years in prison, a maximum of 10 years in prison. I would never, even if you've had a sip of alcohol, get into a car and drive because you are taking a huge risk. Do you understand? Okay, so you may be seated, and I think that,
Are we gonna keep it as a second with the class A?
Yeah.
4.5?
Yeah.
So you're making sure, okay.
yes. Well, they found it. Yes.
No, they found the 0.15 true. The second is an punishment enhancement, which would need to be found true as well.
Guilty.
Yes, we'll stipulate to the first.
Okay.
Doesn't really change anything.
Right, yeah. Okay, so we need him to sign documents, so just don't send them down until the documents are ready to be signed. I'm gonna suspend the license for a year, okay? Do not drive until you get a license. Otherwise, you'll be right back in custody.
Just for the record, Judge, although I've admonished him, well, the court admonished him that this could have negative effects on his immigration status.
Right, okay, yes, that's in fact true, right. You being found guilty of this DWI offense, this can and probably will impact any kind of immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You have an ICE hold now, so you know now that there are immigration consequences for future purposes. When you're on bond, don't violate, there are severe consequences, as you now know. Anything else you'd like? State? No fines. Yeah, I'm not, no fines, nothing else, just, I'll waive any kind of surcharges that will be imposed by the Department of Public Safety. Right, so if you don't mind, give me the motion and then I'll sign it for you.
Thank you, Your Honor.
Okay, all right, so just hang tight, but don't send them down just yet. Okay. All right.